Hear ye, all persons having anything to do before the Honorable, the Justices of the Appeals Court, now sitting at Boston, within and for the Commonwealth, draw near, give your attendance, and you shall be heard. God save the Commonwealth of Massachusetts. Court is open. Please be seated.
Good morning and welcome to the Appeals Court. I'm Chief Justice Mark Green. With me on the panel this morning, to my right and your left is Justice Eric Neyman. To my left and your right is Justice John Englander. We will be the panel hearing all 6 cases that are on the list for hearing this morning. The first 3 cases are criminal matters. We will hear those 3 cases in succession, take a brief recess, and then resume with the civil portion of the hearing list. As you know, each side of the V has 15 minutes to argue. If there is more than one attorney arguing on either side of the V, please let us know ahead of time how you'll be dividing your time, and there is no rebuttal. We will have questions for you during the course of your argument. We mean no rudeness by interrupting you with those questions when they arise. We are familiar, of course, with the briefs and the record appendices, the facts, the procedural background in each case. You needn't go over all of that, and we encourage you to get to the portion of your argument that you believe will increase our understanding beyond what you've already told us in the briefs. If you reach the end of your time before you reach the end of your argument, you may rest on your brief for whatever remains, and of course, if you reach the end of your argument before you reach the end of your time, you needn't continue. The first case on our list for hearing is case number 2023 P354, the Commonwealth versus Ashton M. Ross.
Good morning, Your Honor. May it please the Court. My name is Attorney Sarah Unger, and it's my privilege to represent Mr. Ashton Ross in his appeal of this case. So as you know from the briefs, when the incident underlying this case happened, it's August 2020. The pandemic is still raging, but there's not yet a vaccine. Now, this was part of trial counsel's attempted defense of Mr. Ross at trial. He sort of got out an opening, and he was going to build a case partially around the fact that there was no intent for the assault and battery of a dangerous weapon. Now, intent is obviously an essential element of this crime, and what went to intent and what he tried to present evidence of was that when the defendant lashed out and tried to get out of there, he wasn't trying to kill the officer, he wasn't trying to harm the officer or even necessarily make contact. He just wanted to get out because he could not be arrested. He had a deathly fear of COVID. He couldn't go to lockup.
Also a charge of assault or just assault and battery?
So the two, he was indicted of 2 things. There was armed assault with intent to murder, of which he was acquitted, and assault and battery with a dangerous weapon. And as to that latter charge that he was convicted of, intent was highly irrelevant. So when defense counsel tried to examine each of the officers, what were the policies? He tried to get at what was the mask wearing policy or the quarantine policies.
I understand the theory, and I also understand from the way that the case was tried that the defense counsel, in fact, argued that theory based on readily available evidence and common knowledge, of course, of the jurors. The specific element of evidence that you are identifying that should have been admitted could bear on that theory, but if to the extent that it would bear on the defendant's intent at the time of the encounter, it would have to be accompanied by evidence showing that he knew what those policies were.
And Your Honor, here the defendant was sort of put in a catch-22 because if you allow the defendant to cross-examine the officers on this point, what was your policy? And then you can get into that. Then you can show that. You can show.
How can you elicit from the officers what the defendant knew about the policies?
So this is a defendant with a record. This wasn't his first rodeo.
Sorry?
This is a defendant with a record. This wasn't his first rodeo. You can.
What is it? His
going to put the record into evidence so you can make that argument?
It's sentencing. They get to that, but it's irrelevant. The defense counsel is not going to put his record in evidence to show that he's in and out of lockup.
Right. Doesn't that need to be part of the proffer?
Not necessarily, Your Honor. The defense counsel doesn't have to lay out his entire strategy.
Whoa, but doesn't he? If you're going to make an evidentiary argument, doesn't he have to make an offer of proof?
He says that this is what he wants to get into. He wants to show.
But he doesn't say what it is. We don't even know what the policy.
In order for the policy to be relevant to the question of the defendant's intent, you need to establish as a foundational matter that the defendant was aware of what that policy was. Was there any proffer? Was there any offer of proof? Was there any indication from any source that the defendant knew what the policy was?
Not yet, Your Honor, because one way defense counsel could have gotten to that is through his cross-examination. He could have asked, is this publicly available? Is this publicly posted? Has this...
No. Constructive knowledge does not bear on the defendant's intent. The fact that it was publicly posted would be interesting as an academic exercise, but it would not establish that it was known to the defendant and, in fact, could be presumed to have an effect on his intent or his state of knowledge.
But defense counsel would have been permitted to make that argument. You don't need direct evidence of intent. That would have been convenient. But he could have made the argument, look, this has been in place for X number of months.
So there are two things going on here, okay? One is what Justice Green's asking you about, which is his knowledge. The other is simply, what was the evidence going to be, and how did it help? In other words, what is the policy, and how does that help the defendant? And there's no offer of proof as to what would have been shown as to the policy, right?
That's correct, Your Honor.
So how do we know, how could we determine that your client has been prejudiced where we have nothing in the record that indicates how your client was prejudiced?
Because regardless of what the policy was, defense counsel could have used this to bear on intent. If the policy was lax, then it's obvious. He can show he is afraid because he's going to go in there and no one's wearing masks. He's in there in a cell with 10 other people. If the policy is stringent, he can show, of course, he's afraid. He gets locked up and the entire station is afraid of getting COVID from these inmates. So it doesn't actually matter what specifically...
I remember August of 2020. Incrementally, all of those granular details would have relatively little force in impressing upon the jury the notion that in the minds of every citizen of the world, there was a concern of being brought into close contact with multiple strangers. The policies, whatever they were, would have added very little to the theory that the defense counsel was already able to advance.
So Your Honor is using the phrase like relatively little force. They would have added very little. I cite in my brief Commonwealth versus Papadinus, 402 Mass 73. And that case emphasizes that when a defendant is trying to get in state of mind evidence, it's really not appropriate for the judge to look at things and say, this is a weak argument.
We keep getting back to, to the extent that you're talking about state of mind, you really have not crossed the first plank of the bridge to show any reason to understand that the defendant had knowledge of this particular element of evidence. There's lots of other evidence that we've talked about bearing on the broad theory that could have had some force. But the policies themselves, there is no thread that points to the defendant being aware of what they were, not to mention the fact that we don't know what they were.
True, Your Honor, but again, not to repeat too much, but he could have gotten through cross-examination into generally how aware the public would have been of these policies. And even if you don't think this is an airtight argument to make at trial, that's something that could have and should have gone before the jury. And then
again, as an offer of proof, that information of what was publicly available would have been available to the defense counsel to make that argument, but that argument was not presented to the judge at trial.
Yes, Your Honor, because the judge foreclosed all inquiry into this matter.
Let me ask you this. Would you agree that an intended assault that becomes a battery is a battery under the law?
I'm not contesting that, Your Honor, but in this case...
So just to go forward, it seems to me your theory here is that the defendant wasn't trying to, we don't know if he intended to hit the officer or not.
Correct, Your Honor.
But you're saying, at a minimum, he was either flailing recklessly or trying to scare the officer away or do something of the like, and in the process, a battery occurred. So where's the prejudice if this was, at the least, an intended assault that became a battery?
I am not conceding that this was an intended assault, Your Honor.
Drawing a knife? He draws a knife. That's uncontested,
Yes, Your
right?
Honor.
But you think that drawing a knife on the officers is not enough to show what Justice Neyman is suggesting is an assault?
I think that, no, if you can argue, it all goes back to intent.
Fear of COVID is not a defense.
But defense counsel was entitled to argue that the defendant had an overriding fear such that he was not intending to make
So
contact
you mean
with the
temporary
officer.
insanity?
No, Your Honor.
He intended to draw the knife, right? That was an intentional act. Unless he lost his senses momentarily. He drew the knife. That's an intentional act and an assault.
The jury could have found that, and bearing on that, what could have been defense counsel's argument.
What you're suggesting, apart from temporary insanity, what you're suggesting is that fear of COVID so overwhelmed his capacity to form an intent over his actions that the drawing of the knife was an unintentional act.
I'm not arguing that it necessarily went to capacity. That could have been.
Okay, so help me understand then how fear of COVID mitigates the intentional character of drawing a knife.
If the defendant's only intent in that moment is to get away from these officers, and that is his focus, that's his intent, and he's not
By
intending.
threatening them with a knife.
My point is that it doesn't have to be the strongest argument in the world. If you look
It
at.
has to be coherent.
I agree with that. It doesn't have to be the strongest argument in the world. What we're trying to tease out is so your argument is, look, they artificially truncated cross-examination. They should have allowed the cross-examination to occur. My client was prejudiced. And what we're trying to tease out is, how was your client prejudiced under these circumstances? Your argument, I think, is that he was just trying to push by the guy, and therefore the battery was unintended. The contact was unintended.
Yes, Your Honor.
And then what we're asking is, yeah, but do you have any argument that the assault was not intended? And if the assault, because he drew a knife, because the assault was intended, then Justice Neyman says, well, isn't that enough under the circumstances?
I see what you're saying, Your Honor, but I would again point to Commonwealth versus Papadinus, because in that case, it was similar. This was a case where a defendant was convicted of involuntary manslaughter. Like, this is a sad case where an officer stops him for a traffic stop, and then he ends up dragging the officer to his death. And the court, where the state of mind evidence was barred, the SJC ends up remarking, one gets the sense from looking at this evidence that the defendant was lucky not to have been convicted of murder. They're remarking, that this was a weak case. The defendant was lucky here. The jury could have found all the way up to here. And it has some parallels to this case, where you might see it as a far-fetched argument, but it was still the defendant's right to make, and defendants shouldn't be only given the right to present their defenses based on the judge's gauging of the credibility of their case, or the judge's deciding, hey, the jury's never going to buy this. And so the defendant here, no less than any other defendant with a more ironclad argument, should have been presented, or should have been allowed to cross-examine the officers enough to get into this and enough to present this theory to the jury. If there are no other questions, then I will rest on my brief.
Thank you.
Thank you, Your Honor.
The Commonwealth?
Good morning, Your Honors. Timothy Ferreter, Assistant District Attorney from Middlesex on behalf of the Commonwealth. I think I covered all the points I wanted to hit in my brief, so if there's any questions, I'd be happy to
Yeah,
take them.
didn't they artificially truncate cross-examination in this case? Why shouldn't they be allowed to cross-examine and ask the question that they asked?
Sure, Your Honor. Pursuant to Commonwealth versus ASHTON, The SJC said when state of mind evidence is offered, a predicate to its admissibility is the defendant's prior knowledge of it. Here, there's no proffer that the defendant.
But that is a catch-22, right? I mean, Commonwealth's putting on their case, the defendant has a theory, the defendant wants to help establish that theory through cross-examination. Shouldn't they be allowed the latitude? I mean, they may want to connect it up, who knows?
There was no proffer as to how he was going to connect it up from the policy to the defendant's state of mind.
That's a different point than where I started.
Oh, okay.
I'm not sure why the Commonwealth objected to this evidence. I really am not. I don't understand it, and that's, I think that's why we're here, right? I mean, cross-examination in a criminal case, engaged in by the criminal defendant, they've got a fair amount of latitude, right? They have a right to confront the witnesses against them, and they right to put a defense on.
There are limitations to that, right? And if you're going to offer state of mind evidence, you have to actually have some connection to show that the defendant was actually aware of the thing he wants to say was part of his state
But they haven't put their case on yet. This is still the prosecution's case.
Sure, but when they went to sidebar, the objection was, the defendant's offer was that it went to state of mind. The Commonwealth's argument was that there was no showing that this went to the defendant's state of mind, and the defense attorney wasn't able to proffer anything to the judge, that he was actually going to link it up. So I think the judge in his discretion did not abuse his discretion in finding that there was no way that he was going to link up state of mind evidence. So he didn't cross that bridge right there to, as required, to show that this actually went to his state of mind in any way. And I think the defendant clearly wasn't prejudiced in this case. The evidence as to the assault and battery with the dangerous weapon count was overwhelming. It's on video where the defendant takes a knife out of his pocket, brings it above his head, and slashes it down at the officer. So the evidence was just simply overwhelming. There was no prejudice also because the defendant was able to make the argument. He cross-examined the officers about multiple other things such as vaccinations, masking, how many people were kept in a cell, and he was able to make that argument and make it successfully as to the assault with a dangerous weapon with intent to murder case. That had different intent. That's a specific intent crime. Here the intent we had to show is that the defendant intended to hit the officer with the knife, and the evidence as to that count was just overwhelming.
Did the defendant request a self-defense instruction?
No. There was no self-defense claim. There's no evidence of self-defense.
What do you say to Judge Neyman's question about whether or not the intent to assault is sufficient here, so that really the argument that it goes to the state of mind as the battery is irrelevant?
I think in this, yeah, I think, my sister argues he's trying to push by him. I think that's just not consistent with the evidence, particularly the video. The video shows he takes he takes the knife out of his pocket, brings it above his head, and intentionally strikes down.
That's a factual point.
The theory, though, is that he was so afraid of COVID that upon the police approaching him, he took out the knife not with the intent to stab, but with the intent either to scare away or to frighten or just to move past him.
Yes, and right once that assault.
So with that predicate set.
Right. And so when the assault becomes a completed battery, and when the assault results in contact, it does become a completed battery in that case, yes.
Okay.
And the intent to assault is sufficient.
Correct, once the contact is made.
Make contact. You have an intent to assault, you make contact, that's all you need.
Right, if the intent is to.
It would not be a defense to that to say, well, I didn't intend to hit him.
If the intent is to slash in the area of the officer, essentially being an assault, but the actual contact is made, that would be at least a reckless assault and battery, at the very least, if not intentional. But I think in this case, you can watch the video, I think it's clearly an intentional assault and battery, and being scared of COVID isn't a defense to assault and battery with a dangerous weapon. If there's any other questions, I'd be happy to take them.
Seeing none, thank you both.
Thank you.
Case is submitted. The next case on our hearing list is case number 2022 P1097, the Commonwealth versus DEENHA J. ROMA.
Good morning, Your Honors. Charlie Yellen for DEENHA Roma, and I'm going to focus my comments this morning on the application for criminal complaint. This case should never have come to trial because the application is devoid of trustworthy information to infer intent. There's lots of trustworthy information in the application. It cuts against the Commonwealth.
May I ask you a preliminary question? My understanding is that there was a probable cause hearing here before the clerk magistrate, before the complaint issued. Is that correct?
Correct.
Do we have a transcript of that hearing?
No.
Do we know if that hearing was recorded or preserved in any way?
I don't know for sure.
Because this is a De Benedetto motion, is that correct, that we're dealing with?
This is a motion.
Motion to dismiss
Yes.
for lack of probable cause,
Right.
right? So when there is an actual hearing before a clerk magistrate where evidence is taken, isn't it correct for the reviewing judge not only to review what is in the application for complaint, but the information that was presented at the hearing before the clerk magistrate? Isn't that something that he or she takes into account in discerning whether or not there's probable cause?
That I'm not sure about, Your Honor.
Well, I think that's the state of the law. So how do we approach this if we don't have the material presented to the person who determined that there was probable cause?
My understanding was that there was no, that there is no recording. I'm not sure about that, of the 35A hearing.
Do you think we have the entire record of what the motion judge had?
Yes,
Because you think there was no recording of the hearing
that's my understanding.
and no reference to what evidence may have been presented at the probable cause hearing before the clerk magistrate?
That's right. Now, I could be,
Isn't there some counterpart to Rule 8C that allows reconstruction of the record? I mean, going back to Judge Neyman's point, when the clerk magistrate determines that there's probable cause, they are allowed to take into account all of the information presented at the hearing. And when you're challenging the sufficiency of the conclusion that there was probable cause, how are we to evaluate whether the evidence was sufficient if we don't know what the entirety of that evidence was?
well, I think your review is the four corners of the application for criminal complaint.
Well, I think De Benedetto says otherwise. I think that's what, I mean, look, we're in an area that personally I don't have much sympathy for, right? We're trying to figure out after a trial has occurred whether in fact there was sufficient evidence for the criminal complaint to have issued. But it seems to me, so what you're appealing from is the judge's denial of a motion to dismiss
Correct.
filed in the criminal case. It seems to me that the judge is charged with making a determination as to whether the magistrate properly determined that there was probable cause. If there was a hearing before the clerk magistrate, what was said at that hearing is critical, isn't it?
Well, I think that the judge and the motion judge is reviewing the application and determining himself based on the hearing whether there's.
Then he's not reviewing the right thing. That doesn't make any sense to me. He should be reviewing what was before the clerk magistrate when the clerk magistrate made the determination of probable cause, shouldn't he? And shouldn't that also include what the clerk magistrate heard? I mean, I've been at some of these, not many, but witnesses appear sometimes. People testify.
Well, it would seem to me these probable cause, these magistrate hearings at 35A are, they're designed to screen these kinds of cases out to keep them from the.
Right, but if
I mean, they're supposed to look at the threat of prosecution or persuasion to screen cases out of the criminal justice system to keep them from trial. This case screamed out for that. You've got a contract that governs their arrangement. You've got them parties are lawyered up. This case was designed to be screened out of trial.
Let's assume that we agree with you for the sake of argument that the better use of discretion would have been not to issue criminal complaint. That's still, at best, a discretionary call. Our review is limited to whether or not there was probable cause to make a determination of larceny. And it seems to me your best argument is that they didn't prove intent to deprive permanently. I think the Commonwealth will have responses to that, but could you focus on that element, please?
Well, yes. I mean, you're going to examine the practical considerations of everyday life in determining probable cause. And practically speaking, she lived in the house. She had her belongings there. She doesn't go to retrieve her belongings slinking about under cover of darkness. She goes under cover of this agreement. I know you've got a low bar for probable cause, but there's a bar.
But the agreement specifies she can only take her belongings, right?
Exactly right.
What of the fact that the lock was broken and the deadbolt was gone from the basement, either closet door or door, where the guns were kept?
Okay, so we can assume the guns were kept in this closet.
We can further assume, I think, or assumes the wrong word, viewing the evidence in the light most favorable to the Commonwealth, I think a reasonable inference is that either she or someone that was helping her intended to tear that bolt down to get whatever was in that closet.
Well, again, in the light most favorable to the Commonwealth, you're saying that there was a locked door.
That's the evidence, but that's in the police report.
No,
that
the
has to be
police
accepted.
no, the police go down to the closet door. They see an unlocked door. They see an unlocked door. The brother says, the lock's in my bedroom, upstairs.
I believe in the police report, isn't there evidence, I can look at it right now, that there was a broken deadbolt?
This room had a door with no doorknob or deadbolt. Tony stated the doorknob and deadbolt were removed and that he had them upstairs.
In his bedroom.
The doorknob and deadbolt lock were removed from the basement closet door. And then there's photographs as well. Isn't there a reasonable inference that that was broken?
And my point is, it doesn't matter whether it was locked or it was unlocked, because if you look at the agreement, it says she has a right to take her seasonal decorations and her storage bins that are in the basement. First of all, we don't know anything. We don't know how big these things are. We don't know what's in the storage bins. But more importantly, we don't know where in the basement these items are. If they're in the closet, she can go get them.
Those sound like arguments to be made to a jury at trial. Again, the standard is not even reasonable doubt. We view the evidence in the light most favorable to the Commonwealth and determine whether there is probable cause to believe that a crime was committed.
Reasonably trustworthy information.
Right.
Well, you need to also look at the totality of circumstances here.
You think it's not reasonably trustworthy? Tony stated the doorknob and deadbolt lock were removed from the basement closet door?
No, I think in the light most favorable to the Commonwealth, I agree with Justice
Reasonably
Neyman.
trustworthy. And
the
then
door was locked, but it's
and
not.
I'm going to connect that to, other than the washer dryer, all items shall remain in the basement being landlord's personal property.
Except for,
Yeah, I can't find that right now, but I know it exists. But that doesn't really matter, because it seems to me that if you have this sort of structure and then someone goes downstairs and takes a deadbolt and a lock off a door, okay, and then you then have further testimony, and there were things in the basement that were mine that are no longer there, isn't that enough for probable cause that she intended to deprive the person of those items permanently?
if she has her items in the closet, she has a right to go get them.
She can take her items, she can't take the things that aren't hers.
Where does it say she took anything else from the closet?
I didn't hear your
I'm
response.
sorry, it doesn't say that, there's nothing in the police reports that says she took anything else from the closet. All their,
Guns, where did that evidence come from?
Okay, the guns are wrapped. Again, Chief Justice Green, you're going to look at the totality of circumstances. And the most important thing there is when the police come knocking on her door, what does she do? She invites them in. She gives Officer DeRosa the run of the house. Then when he leaves, he describes what this package looks like, and that it's got the guns. And she says, I'll call you immediately if I find it. She calls the next day. She's not indifferent to the status
I'm
here?
not sure how much the guns matter, counsel. Let's take the guns out of the picture. I understand your argument as to the guns. What I don't understand is the statement you just made, which is that there's no evidence that anything else was taken. I'm looking at a handwritten list on RA 17 that he provided of all the things that were taken.
You're looking for trust. We're at the probable cause stage.
Yeah.
You're looking for trustworthy information. He's got this contentious relationship with his sister. What makes if my brother, not the brother-sister type of thing here, if my blood brother comes to you and says, I have a contentious relationship with my brother Charlie, he stole my baseball cards, you're not going to put me on trial for that. That's what his statement.
But you're arguing discretion, which we all understand. But that decision was made, and our standard is probable cause. You're asking, I think your argument amounts to asking us to ignore the list on RA 17 because we determine ex post that it's not reliable. We wouldn't be able to do that if it were the evidence presented at trial to determine beyond a reasonable doubt, would we?
You know, I think when you're looking at all the information here, you've got the police reports. That's unquestionably reliable. You've got Anthony's list, his list of items he says are stolen. I don't know what makes that trustworthy.
But you're suggesting, if I understand you correctly, that in determining what is reliable, we should depart from the ordinary standard of our review of determinations made by a trial court official on credibility, and that we should conduct a de novo assessment of credibility of in this case, the affiant.
Well, there's something about, the case law is clear. You've got to look at trustworthy information in the light most favorable to the Commonwealth. The word trustworthy is thrown in there for a reason.
I understand that, but do you have a case that applies that question of trustworthiness in the manner that you're now suggesting, that an appellate court sets aside a determination by the clerk magistrate or the motion judge to credit that information because of the identity of the affiant?
I'm not sure I have a case exactly
I'm pretty sure you don't.
on point. Okay. Well,
It would be a fairly substantial departure from all of the foundational underpinnings of our system otherwise.
I would want to make sure that you focus on a key part here, and that is when you're saying if you're saying the guns are not the issue. I don't know how we can say that where the parties agreed, where the Commonwealth and the judge both said the larceny is the guns. When the judge writes his denial of the motion to dismiss, he writes up in his notation, basically the larceny is about the guns. The Commonwealth can't, I don't know if you call it judicial estoppel or the more colloquial second bite at the apple, the Commonwealth can't come now and talk about the non-guns.
Well,
they've already narrowed the issue to
That evidence was presented, right? The evidence of the non-guns is presented. It's there. You have to win the argument against all the evidence that was presented, don't you?
at the motion to
Let me ask a different question, counsel. If we take the guns out of the picture, you make an argument with respect to sufficiency of the evidence at trial. It's basically, look, other than the guns, they didn't prove anything else that was stolen. If we take the guns out of the picture, is there any evidence that there was more than $1,200 worth of?
No. There's no evidence. I don't believe there was any restitution made. I don't think he had no documentation. He had no photos. He had nothing to show that he had ownership of any of the property other than the guns, which were not hers.
What about the television?
There's no
He says, I bought that. At least I think I read that testimony in his trial testimony. I purchased that Samsung TV, and it was right there, and now it's missing. And I think he says at the time I purchased it, I probably paid about $1,500.
And she said, I think in the police reports, that the TVs were hers, that she purchased everything. She, I think that she exhibited behavior, quite frankly, Your Honors, that in helping the police, that courts should want to encourage police departments across the Commonwealth would welcome her help in finding the guns. The guns were the issue.
Your time has expired, but I have one more question for you. No, don't apologize. The officer put in the police report that this is a civil matter, and I think that makes this something of a more interesting case. But would you agree that the motion judge was not bound in any way by that statement?
Yes.
Okay.
I think you need to consider the totality of the circumstances, and that's part of it. Thank you.
Thank you. For the
Thank you.
Commonwealth?
Good morning. May it please the Court, Julianne Campbell on behalf of the Commonwealth. I'm here asking that this Court affirm the defendant's conviction, and I'd suggest that in the light most favorable to the Commonwealth, at both the motion to dismiss stage and at the conclusion of the defendant's bench trial, I'd suggest the evidence was sufficient to support the defendant's guilt.
Can we start by addressing the appropriate review here? I understand what the standard is, but are we reviewing just the application for complaint? Or shouldn't we also be reviewing a transcript of the testimony that was taken and the evidence presented to the magistrate judge?
So I can't speak to whether a recording of that hearing exists.
But the hearing did occur.
Based on the record, it appears that it does, and I point specifically to page RH 52, which does not indicate that either party failed to appear at a hearing, and it does indicate that a complaint and summons was to issue after.
The parties agree at the hearing, at the De Benedetto motion before the motion judge, did the parties agree that the correct universe for purposes of this case was the application for complaint and the police report attached thereto?
I don't believe that that is in the transcript of that hearing.
What should a judge do? So I'm a district court judge, I get a De Benedetto motion, I look at the application for complaint, I see there's an attached police report, and I see the box check that a hearing was held. Should the motion judge order the parties to go and get a transcript? As a practical matter, because district court judges face this every day, and we need to resolve, or at least help them resolve, what the appropriate universe of facts is to consider the motion. So what should be done in that situation?
I appreciate the question, Your Honor, and I recognize, having been in this position before, that it does frequently occur. I would suggest that where there is an indication that a hearing occurred, a judge is under an obligation to make an effort to find out what happened. If there is no record,
The judges, it would seem, so probable cause was determined.
Yes.
Right? So isn't it the defendant's burden, if they want this dismissed, to come forward with the proper evidence?
So a defendant's obligation under a motion to dismiss is to demonstrate that there is no probable cause. Right. I would suggest that a defendant should point to whatever they can. However, a judge has an obligation to review the entirety of the record in determining whether, I think it would be.
I'm sorry. Chief, you want to?
No, you go ahead. You're on it.
I think we're in exactly the same place, which is this. When we get this, it's like an appellate record, right? When we get it and the person who wants something overturned has not bothered to get us all the information from which we can determine whether the judge made a mistake below, we don't do it. We say, hey, you didn't give us what we need. And it seems to me that's the position that this judge is in. He's being asked, or she is being asked, to dismiss the case because there was a lack of probable cause. It seems to me if you want to ask the judge to dismiss the case, you need to do what you can to get before that judge everything that was before the person who made the probable cause determination.
I'm not disagreeing with Your Honor at all. In any way. What I would suggest, however, and this is sort of outside the scope of this, but in practice, If a defendant does not refer to findings made after a hearing, I would suggest that does not alleviate a judge from reviewing those findings if they exist.
It's the defendant's challenge based to suggest the defendant is saying that the prior determination that probable cause existed on the basis of the evidence was incorrect. And they are asking a judge to overturn or reach a different conclusion about the existence of probable cause based on the evidence presented. If they don't put before the judge that they are asking to make that determination all of the information on which that determination previously was made, you're saying that the judge has an independent obligation to conduct an investigation?
No, I'm in a bind, Your Honor, because I'm considering cases not before this court right now and other iterations of this. And
So are we.
But what I have seen, Your Honor, candidly, is defense attorneys filing a motion to dismiss, relying on four corners.
I'm aware of that.
And there's.
We've seen those cases too.
Correct. And so, but I don't think a judge is free to ignore, if there's a transcript of a hearing in the clerk's file, papers from the court that refer to that.
So in this case,
That's my only point, and that's not in this case.
in this
All this is
case,
doing is convincing me that we went down the wrong road. And what was the
Well,
name of that case?
I-
McCarthy?
in,
McCarthy, yeah.
in this case, in this case, so we agree that the transcript of the hearing was not put before the judge, correct? The motion judge.
Correct, and I would suggest that the record as it is before the
And the
court.
fact of testimony before the magistrate was not put before the motion judge, correct?
Not by the defendant's motion, correct.
And the ADA said at the motion hearing at page 7, I would rest on the police report.
I'm happy to, then, at that
Says
point.
So based on that, where we have the fact of the hearing and the transcript not being before the judge, so the defense hasn't satisfied its burden to put it before the judge, and the prosecutor rests on the police report, can we say in this case we have agreement on the relevant universe of facts?
Yes, and I apologize to the court that that portion of the record had escaped me. But yes, in this posture where the Commonwealth relies on the report, but I do think the report includes the affidavit of the complaining witness here, and I'd suggest that between the police report and the complaining witness's affidavit and exhibits, there is probable cause
So
here.
to get to the merits of the argument, and I want you to focus on intent to deprive permanently, that element.
Certainly.
You agree that the defendant in this case returned the guns ultimately.
Yes.
So why doesn't that negate intent to deprive permanently?
For several reasons. One, I would suggest and I'm not, the first being, I think you can infer an intent to deprive when the police have to come looking for the stolen property, which is precisely what happened here. You can also infer an intent to deprive, I'd suggest, from the ongoing hostility, the complete destruction of the home, the fact that the locked doorknob and bolt was removed, the fact that all of his property is missing, one piece of that being the firearms, was in fact returned.
Are we talking about inferring that for purposes of probable cause, or are we talking about inferring that for purposes of beyond a reasonable doubt?
I apologize. I was referring to the trial evidence, but if it would suffice at the trial, I'd suggest.
Well, no, I mean, I don't know what Judge Neyman was asking about, but I would like to focus for a moment on the evidence at trial.
Sure.
So so your argument is that there's sufficient evidence with respect to the guns of an intent to deprive permanently, and that comes from the fact that she trashed the house, she removed a deadbolt in the room that the complaining witness says is where the guns were kept, and the general hostility. Anything else that I mean, because police officer shows up, she says, come on, take a look around. Oh, if I find them, I'll let you know. And the next day, here they are.
So are you, just to clarify, you're referring to the trial evidence?
Yeah, I'm referring to trial.
So I think there's a couple of things. I think the scope of the trial evidence expands quite a bit when the defendant testifies herself. I think she, and through her testimony about the various items that were missing and how she characterized them.
Was there a Rule 20 what, Rule 29? Was there?
That's 25B.
Rule 25, was there a Rule 25 motion?
I believe there was at the close of the
So
Commonwealth and the.
let's focus on the evidence that
Sure.
came in for the Commonwealth.
Sure. So again, I think the evidence that Your Honor recited in the light most favorable to the Commonwealth would suffice to prove an intent. Again,
An intent to deprive permanently, that's what the
yes,
case
and
law
the
says, right?
yes, and the reason is because I understand the defendant's argument that she was helpful to the police, but as the police report describes and the officer testified, he essentially was walking into a storage locker packed to the brims and saying, hey, sure, poke around, I'd suggest is not indicative of an intent to return stolen goods, especially when the majority of them were not returned.
Well, the difficulty with that is that, we're just talking about the guns now.
Yeah.
We're going to get to the other stuff, right? But the difficulty with that, it seems to me, is she then went and looked, found it, and on her own said, here it is.
I would suggest that's indicative of perhaps a consciousness of guilt when the police show up looking for stolen firearms and the only thing that's returned are the stolen firearms, because that's what got the police looking.
So you're saying day late, dollar short.
Yes.
So what if, same set of facts, but defendant goes to the clerk magistrate, goes and seeks a complaint, and before the police get involved,
I'm sorry, the defendant went to?
sorry, the victim.
Okay.
Thank you for clarifying. The victim goes and seeks a complaint before the police get involved, and complaint issues, but police aren't involved. She becomes aware of this, and she returns the guns.
I'd suggest you're looking at the intent at the moment of the theft. And so where there's any type of delay in returning it like that, that is of some significance and is only after negative action has begun, I would suggest that you can still, beyond a reasonable doubt, find an intent to permanently deprive at the time of the theft, much the way you would for a breaking and
Under that
entering.
theory, every time someone makes a mistake, it's going to require a trial in order to undo the mistake. That seems awfully harsh to me.
I would suggest, I'm dealing with the case before the court today, and I understand the court's position, but I'd suggest that on this
It's not a
record-
position. We don't
Well,
have
fair
a
enough.
position yet.
Inquiry. I understand the court's inquiry. I think that not every case would necessarily go to trial. I don't know that this case would necessarily always go to trial. It did here, and I'd suggest that all of the evidence supported the defendant's guilt.
Do guns matter? Let's take the guns out of the picture.
Sure.
You still have enough for larceny over?
I think it's a more challenging case because you don't have recovery of the property. It's still a circumstantial case, and in that way, I think I
Didn't the
can't.
victim testify,
Yes.
hey, there was a TV right here, I bought it, it's gone?
Yes.
I paid $1,500. Is that enough under Lattimore?
So I think the Commonwealth, that would certainly be a more difficult circumstantial case for the Commonwealth. However, I still think an individual could find an intent to permanently deprive and circumstantial evidence that it was the defendant who stole that item, but that is not the case before the court.
Did the victim testify to the value of the items
I don't
stolen
believe
at
a
trial?
dollar amount was testified to. I would suggest that the judge, in light of the testimony regarding the items that were taken, could apply common sense and assess that.
It seems to me that under Lattimore, that's not a bad case, and I'm not understanding why you're hesitant about it. I mean, I'm just talking about under Lattimore. Maybe, when you're sitting around in a room trying to decide whether to bring the case, maybe it's circumstantial, but
I agree with Your Honor.
The defendant admitted to the police that she took things from the house. One thing that the victim says was there was a television. He says the television was there before she went in. It's not there afterwards, and I owned it. Isn't that enough?
I agree with Your Honor, but I'm thinking in the context of a circumstantial case in a jury. So I would like to think that, and on appeal I might argue that, but I have to concede that that would be a more difficult case for the
And the
Commonwealth.
guns, because you found the guns.
Yes.
Problem with the guns is she gave them to you.
But again, my suggestion is that it's,
Fully wrapped. She doesn't even know what's in them when she gives them back.
that's her defense, which the judge was free to not credit, Your Honor.
But there's no evidence whatsoever that the wrapping had been touched.
Your Honor,
As I understand it, they were wrapped and sealed.
Your Honor, my argument is that there is a large amount of property that was removed from, and the only thing that was taken and found in the defendant's possession was what she returned after the police came looking for reported stolen property. So in light of that, I'd ask this court to affirm the defendant's conviction. Thank you.
Thank you. We move to the third of our criminal cases, case number 2022 P869, the Commonwealth versus Charles G. Williams. And just as a reminder, we will take the morning recess following the conclusion of the argument in this case.
Good morning, Your Honors. May it please the Court. My name is Richard Hartquist, and I have the privilege of representing the appellant, Charles Williams. I'll open and probably primarily focus on my first argument in the brief, and that argument relates to what we're calling an unconstitutional search. It's a warrantless search, which, of course, the Court is aware, is per se unreasonable. The motion judge in this matter has definitively stated that there was no reason for police to believe that there would be any evidence of the Parham shooting in the vehicle at the time that the backpack was seized. She seems to have...
Repeat, say that sentence again. There was no, who said there's no reason to believe?
The motion judge stated that she found no reason to believe that there'd be any evidence of the
You're not
Parham
asking
murder
us
in
to
the
endorse
vehicle.
everything that the motion judge did, are you?
I'm sorry?
You're not asking us to adopt whatever the motion judge said?
I am asking you to adopt some of what the motion judge said.
Everything?
Not everything.
Okay, well, let's start from the premise that whatever the motion judge said is fair game for us to review whether we agree or disagree.
Fair enough. All right.
If you want us to adopt it all, we will, but I don't think that's where you want us to wind up.
Absolutely not, Your Honor. Thank you.
So we don't have, at least I haven't been able to locate a transcript of the suppression hearing. Was that provided by you folks?
I believe it was. I have it. I can provide it to the court for sure.
Was it argued at any time to the motion judge that there was reason to believe that there might be evidence related to the crime in either the backpack or the car?
I don't believe that the district attorney took that position. The district attorney fashioned it as an inventory search at one point. It looked like the motion judge was calling it a search incident to arrest. I'd respectfully argue that it can't be either one, right? The car wasn't inventoried. It wasn't taken into possession of the police. In fact, the officer on scene, Officer Murray, called Sergeant Detective Devane, said, "Do you want the car?" He said no.
It's not an inventory search of the car. Agreed.
Okay? So then we have search incident to arrest, right?
Didn't she find that the backpack ultimately would be inventoried? That was the basis for her decision.
The backpack couldn't be inventoried if it couldn't be seized.
Well, okay, fair enough. But if there's a finding, if there's a determination by the judge and then by this court that the seizure was appropriate, then what?
If the seizure was appropriate, then the inventory would lead to discovery.
Okay.
My attack is certainly on the seizure, right? The police have no safety concern at the point this is taken out of the vehicle. And in this court...
When did the seizure occur?
The seizure occurred after the defendant had been transported and after the defendant's spouse had been handed the keys to the car.
As a legal matter or as a physical possessory matter?
I'm sorry?
As a legal matter or as a physical possessory matter?
I'd argue both, right? The defendant was off the scene. So as a legal matter, there were no safety
6 minutes.
concerns. He was handcuffed.
According to the findings of the judge, which I understand you not to contest, 6 minutes after the arrest, 6 or 7.
Agree.
Right?
Agree. And that was the testimony at trial as well.
Let me back up for a moment because I want to zero in on the question of seizure. The police removed the backpack from the car 6 minutes after the defendant departed the scene, and that is a seizure in the common parlance. But as a legal matter, weren't wasn't the car, along with the defendant and the backpack, seized when the police surrounded it?
I would argue that it was not seized.
The legal matter, the boxing in the car did not constitute seizure?
That would constitute an arrest, right, according to our case law, but it doesn't mean they seized the car. They didn't take it into custody.
They later relinquished the car to the custody of the girlfriend. But I'm a little fuzzy on some of this stuff. I haven't done the full research because the car is not at issue in this case. But I would have thought that the stopping of the car constituted a seizure, at least at that moment. Whether they continued that seizure or not.
The stop of the vehicle doesn't constitute a seizure. I think Commonwealth
Wow. A stop is not a seizure?
the car wasn't seized, it wasn't taken into custody, it wasn't impounded.
At the moment that the arrest occurs, your client is sitting in the car. Police have taken control of that area, have they not?
The police take the defendant out of the car and seize his person.
But don't take him out of the car yet. At the moment that he is confronted, arrested, he's in the car. The police have taken control of that area, correct?
That's fair.
Okay. And isn't that a seizure?
I'd argue that it's not a seizure, it's temporary. There's no intent of taking the car, and they don't take the car.
Well, as to the car, but...
They certainly intend to seizure the defendant, and they effect that seizure.
Right.
And as soon as they complete that seizure, and temporally speaking, as Your Honors have stated, minutes pass before Ms. Rivera has the car keys in her hand.
Let's imagine a slightly different circumstance where Ms. Rivera doesn't arrive at the scene.
Okay.
They've stopped the car. Let's set aside for the moment the loaded nomenclature of seizure. They've stopped the car. They've pulled the defendant out of the car, and now they're confronted with the question of what to do with the car. Because whether they've seized it or not, they have it, right?
Correct.
Okay, and we'll return to that. That's just a placeholder. In ordinary course, if there was no one else to whom to commit custody of the car, what would happen?
The police officer would have to make a determination whether the car was in a hazardous place, whether it was a danger to the community. Police are often...
In what circumstances would they simply leave the car in that location?
We're talking about a fact pattern that doesn't exist, right?
I'm just talking about one slight deviation where Rivera doesn't show up. So let's bear with me for the moment, okay, please?
Police have to ask the defendant, and this is the Gonzalez-Mendez case, right? Police has to ask the defendant whether they want them to leave the car for someone else. Defendant says yes, leave it for Ms. Rivera. Police have to do that.
Okay, but do they have to leave what was on his person when they arrested him?
On his person, no.
Or within his lunge area?
Within his lunge area, it's not his lunge area once he's out of the car. So I argue there's two...
That is directly contrary to Figueroa, right?
Contradictory to...
Figueroa, Justice Gantz. Figueroa, he says it's at the time of arrest. And I'm not making this one up because I know it was cited in the briefs on the other side.
So I understand that.
Your position is directly contrary to Figueroa.
And I would say that I can cite several cases that are directly contrary to Figueroa.
Okay, but Figueroa seems to me to be pretty good precedent.
In this court, once Gant was decided, and once Belton...
Let me ask you this question about that, because I understand what you're saying. I'm interested in the cases that you're going to cite. But is it your argument, because I did not read this, that Figueroa is inconsistent with federal law?
Yes.
What federal law says that you don't do it as of the time of arrest?
Gant, well, I would say that all these cases that I would cite, there's a gun in the vehicle or there are drugs in the vehicle, and they're all within reach. And it's generally, the case law also says that we generally think of everything that's in the cabin of a vehicle to be within reach.
Yeah,
So-
but this is, you're not disputing that a backpack on the passenger side, when he's sitting in the driver's side, is within his lunge area or his reach.
It's within his
It
reach.
would have to be a pretty big car.
Within his reach prior to his arrest.
Right.
And then as
Okay.
soon as he's safely taken out of the car, it's no longer in his reach and it's no longer a safety
You can
concern.
agree on all that, but let's go back to Figueroa. Figueroa says, in determining what is legitimate for a search incident to arrest, it's what's within his reach at the time of arrest. It's within his reach at the time of arrest. You're not contesting that, are you?
Well, I would contest the fact that he couldn't access the gun at the time of the arrest, right? It was in a closed container.
Oh, boy.
Case law says that doesn't matter.
Understood. We also
In fact,
have
I don't
case-
think it, I know it says that.
we have overturned case law that says you can go into the glove box as well, right? But
That's not, wait,
that's-
now you're, that's misdirection. And I don't mean it that way.
Let's just be clear on one question, because you've been a little inconsistent so far in your presentation, I think. When was the arrest?
in time,
Where was he?
in the seat of the car.
Okay.
He was asked to
Okay,
exit the
so
car.
we agree that he was in the seat of the car at the time of arrest. We
And the
agree,
backpack is on the passenger side.
Correct.
we agree that the backpack was within his reach at the time of arrest.
So let me ask you this. If at that point in time, they take him out of the car, they arrest him, and the officer immediately grabs the backpack and opens it, constitutional violation or no?
Well, we have a warrantless search. I do concede that the police officer could grab the backpack. The arresting officers could have grabbed the backpack.
Open it and see what's
Officer-
inside is a search incident to lawful arrest.
So,
Yes?
yes.
So, here there is a delay, and I know there's a mention of 6 minutes. I'm actually looking at Record Appendix page 85, in which the judge found that Murphy transported the backpack from Williams' car and secured it in Murphy's car. This happened 2 to 3 minutes after Williams left in the prisoner transport. And it's at that point that Officer Murphy opens the bag, feels it, and opens it to see what's in it. So if 2 to 3 minutes have passed,
Yeah, but it was 4 minutes before he was transported.
let's even assume it is 4 minutes total. What does the case law say about that? Does 4 minutes fall into the federal exception of allowing a reasonable delay between an arrest and otherwise permissible search, or is that 4 minutes too long? And what's your best case on point?
So I make two arguments in this, that there are two temporal breaks for Fourth Amendment to intervene, right? When he's taken out of the car and he can no longer reach it and it's no longer a safety concern, that's a break. Now, that's right after he's arrested, so if someone comes over and grabs the backpack at the same time, maybe that's fine, but that's not what happened. What happens is Murphy calls Detective Sergeant Devane, and Devane tells him, I don't want the car, and Murphy gives the keys away.
So we want to
that's another-
discourage officers from being careful and checking with their boss very quickly?
Well, he did that, and the decision was made because there was no evidentiary value to the vehicle. The keys were given to her. Now, what if, I mean, I guess the counter-argument to that is, what if they decided after they were talking the following day that they should have grabbed that backpack? Can they come back the next
Case law
day?
certainly says a couple of hours is too long. In fact, it says that I think an hour to an hour and a half delay is far too long. But I believe there are some cases that say a very brief interval between the time of the arrest and the subsequent search incident to arrest, i.e. a period of a few minutes or less, may be okay, depending on the totality of circumstances.
But I would argue that the break can't be temporally measured. The break has to be event modified, right? He
Well,
comes
wait,
out.
no, well, it can't be temporally measured?
We can't say 5 minutes is enough when 6 minutes isn't enough because the facts always
But I thought you've already
vary.
conceded that if there is no temporal break, it's okay. So the officers came from two different directions. One opened the passenger side door, one was at the driver's side door, right? When they came in, they could have opened that backpack and looked in it at that point. He's sitting right next to it, right?
But they didn't.
Okay, but so that's my point. So temporal matters in your argument, because if you're conceding that the Fourth Amendment wouldn't be violated if they'd done it immediately, your argument has to turn on the fact that they waited.
My argument turns on the fact that they gave possession of the vehicle to Ms. Rivera.
Not the backpack.
The backpack was within the vehicle. Remember, the officer had already searched through the
Oh, it had
car
been the
before giving the
defendant.
keys up.
They may have given her the keys. They hadn't given up the car. They were still talking to their boss about what he wanted to do. She couldn't have gone in that car until they were going to allow that to happen. And I think we've got more questions probably,
She
so
had
don't
the
worry
keys
about
in her
that.
hand. And the officer had made the first
She
phone
couldn't
call.
go in that car till the police were going to allow her to go in the car.
What if there were a dozen more phone calls? There were 3 phone calls that we know of.
But there weren't,
And
right?
even had there been, she wasn't going to be allowed in the car until the police authorized her to do so.
The fact of giving possession of the keys is indicative of them giving her the car.
It is a factor, but they, in the circumstances, in the reality of that scene, they still had custody of the car. They'd given her the keys to hold, but they were not allowing her to drive off until they determined what they were going to do, no matter how many phone calls that took.
The officers had left the scene. The fugitive unit was gone.
The officers had not left the scene.
Officer
Officer Murphy was still there.
Absolutely.
He called his boss. He said, hey, and he, by the way, the other officer must have still been there at the time, because the reason he learned the backpack was on your client's back was because he heard that from the other officer. He then called Devane back. This all happened, I think the reason I said 6 minutes is because the way I read the findings of the judge is 3 to 4 minutes before Williams is transported, and it's 2 to 3 minutes after Williams is transported that they seize his backpack. So this is all happening very, very rapidly. Let me ask a different question. Why, if we were to, it seems to me your argument amounts to the following. It would be okay for the officers, it would be reasonable under the law for the officers to make the search at the time of arrest, okay? But it's not reasonable if they wait afterwards, because at that point security concerns are gone. So aren't we then saying, hey, if you want to search, you need to do it immediately? And isn't that exactly the concern that Gantz talks about, I believe, in Figueroa, where he says we don't want to incent the officers to not be focused on their own safety by giving them a rule that would require them to do the search immediately?
The reason I think the Commonwealth has a basis for an immediate search is because Mr. Williams walks out of the apartment with the backpack in his possession. He then dispossesses himself to some degree by putting it on the seat, but he's not fully dispossessed, right? Then the police ask him out of the car. Now he's fully dispossessed and safety concerns are gone, okay? Then the assumption is that there's nothing really likely to be in this car from the Parham shooting. Now, I argue that once he's out of the car, safety concerns and probable
Did anybody
cause
testify to
disappear.
that? Did anybody testify to that, by the way? You've said, it's the second time you said it. The first time you said it, I questioned where you got it from. Did anybody say, hey, there's not likely to be anything here from the Parham shooting?
Well, there's 2 people who said it. The judge said it in her motion here, her motion findings, and I suggest to you that Detective Sergeant Devane said it when he said, I don't want the car.
I don't want the car. He didn't say I don't want the backpack. In fact,
Well,
he said the opposite.
Again, that was a phone call later, right? But I'm arguing that once the police took him out, I argue that once the police took him out, the Fourth Amendment protects the backpack because there's no safety concern and there's no likelihood of anything from the shooting. After that, and the reason I say that is we're 4 months post-shooting. That's a factor here, right? Then after that, when the officers leave with the body, there's one officer left making phone calls. He makes the call. The officer...
Search incident arrest is about, a big chunk of it is fundamentally about the police being able to protect themselves and maintain their safety, right?
Correct.
Okay. And we've already heard an argument today, I don't know if you were here when it was argued, about a police officer who got stabbed.
I didn't hear it.
In a simple, hey, we need to take you out of the hotel. Okay, so it's real. These problems are real, right? And we have to worry when we're making our rules about whether or not we're making them so complicated that we're putting officers at risk, don't we?
No one's at risk once the defendant's in full custody, handcuffed.
Okay, but if the officers are told, if you make that search immediately at the time of your arrest, it's okay. But don't wait 5 minutes. Aren't we then making it a pretty complicated rule for officers to have to follow in the immediacy of a situation?
The idea is generally that they're going to search the person, right? They're going to search the clothing, they're going to search the heavy coat, they're going to check the waist, they're going to make sure there's no weapons on the
And
person.
anything within their lunge area, right?
Once that's done, the Fourth
No,
Amendment
and
is
anything
implicated.
within their lunge area. Isn't that what the cases say?
Immediate lunge area.
Yeah.
But he's out of the car
For the
and
same
car's given
reason.
back. And again, if there's no connection to the Parham shooting, if they just want the body, and if there's no likelihood that anything's going to be from the shooting in the car, then it doesn't make sense to release the car and then take the car back. And it seems to me that if we can release the car and take the car back in a few minutes, then we can release the car and take the car back in a day or in a week.
You keep saying there's no likelihood that there's going to be something in the bag associated with the Parham shooting, but it seems to me that's why Devane wanted it, because guns are items that are usually not disposed of, they're expensive, they're personal, they're evidence. We have lots of cases that say that. So, and lo and behold, they did find the weapon that was used in the
Murder weapon
shooting.
had never been found.
Correct. And I'm citing the motion judge when she said there's no likelihood, based on what she heard, that they were going to find anything in there. And I would, again, argue, we have a break point when he's out of the car. It's not in his lunge zone anymore. We have a break point when they hand over the keys. Time passes, and it seems to me that the Fourth Amendment becomes implicated, not in terms of minutes, but in terms of possession.
Right. I think we're going to have to leave it there. We're significantly over time, and we've covered
Thank you very
this.
much, Your Honors.
Thank you. For the Commonwealth?
Good morning. May it please the Court, Erin Knight on behalf of the Commonwealth, asking this Court to affirm the defendant's conviction. Please bear with me, I have a little bit of a voice today. I would first like to acknowledge the family of Mr. Dennis Scooby Parham, who is joining via the YouTube feed today, as well as the trial prosecutor, ADA Tara Birdman. I do think, Your Honor, that this is a temporally significant happening. The decision to arrest the defendant was made, of how to arrest the defendant was made because of his size, because he is a violent felon, because the gun had not yet been found. And it's in the testimony of, I believe, Officer James Clark, that this defendant was significantly larger than every single one of the officers of that fugitive unit that were on the task force to apprehend him. So the decision was made right before he entered the vehicle to let him enter that vehicle, so a foot chase would not ensue, a car chase would not ensue, and the public would not be at risk.
I don't understand the concept that a car chase wouldn't ensue, but I don't think anybody's really challenging the, I mean, he'd already started the car, so letting him get in the car, it seems to me, is pretty risky. But I don't know that anybody's challenging the notion that a tactical decision was made, right?
Sure, and the only reason that I say that is because I do think it envelopes into Judge Roach's decision, which was she took the backpack motion in two parts. She took the seizure of the backpack and then Officer Murphy's search of the backpack. She took that in two parts. And in her motion findings, she found that the seizure of the backpack under whatever the three different ways, warrant exceptions the Commonwealth put forth, to have been reasonable. So the seizure itself, she found reasonable under both search incident to arrest,
Actually,
protective, and inventory.
She didn't, and it's not, she doesn't, the reasonableness finding is not in connection with search incident to arrest. She rejects search incident to arrest. Then she goes on to the next section of her opinion where she says that it's reasonable, but it seems to be a free-floating determination as far as I can read.
Your Honor, if I may, I would just point to Record Appendix 97, where she says, in this regard, it is important to distinguish between seizing the backpack and opening the backpack. As discussed below, I find and rule that the seizure, removing the backpack from the vehicle that was being turned over to Williams' female friend, was reasonable and therefore lawful. And then if you continue on in her...
She says the seizure was reasonable, but she doesn't couch that reasonableness by reference, or she doesn't ground it in its being incident to arrest.
I would just, again, point back to, I would point back to her findings in, for example, at page 100, where she goes on to state that the search of the backpack was not lawfully made incident to arrest, so that is not an exception to the requirement. And then she goes on, based on the totality of the circumstances, the seizure of the backpack at the time was reasonable. That's on page 101 under her protective search exception.
I see that, but I will confess to you that I highlighted that paragraph in reading through her decision because it's a little ipsy-dixit. I know she includes a reference to Abdallah, but when I looked at Abdallah, I couldn't see quite as clearly as she seems to have intended exactly what part of Abdallah was supposed to support her rather breezy conclusion that it was reasonable.
Sure, Your Honor. I would point to pages 52 and 53 where it talks about the totality of the circumstances for reasonableness. And while Abdallah is opposite to our case where they found that the police shouldn't have taken the backpack at that time, I think the totality of the circumstances is exactly what we're looking at here. They were going to arrest him anyway. He had the backpack on him when he exited the residence, and when he got into the car, he then put it onto the passenger seat. So I think looking at the totality of the circumstances, in her mind, that Abdallah was reasonable. Abdallah, to this case, is more reasonable in this case because he was being arrested for murder. The weapon had not yet been
Abdallah concluded that it was
found.
not reasonable to seize the bag, right?
I'm sorry, can you say that?
Abdallah concluded that it was not reasonable to seize the bag.
That is correct.
So what is the case that suggests in similar circumstances that it is reasonable?
Sure. I would point to the fact that I would point to Figueroa. I would point to, well, I would say Oliveira, but opposite of.
Figueroa is different because that is a case, as Judge Englander has observed, that justifies the search as incident to arrest, and the judge here explicitly rejected that theory. We're not bound by that, but we're talking about something different. I looked at what the judge said, and she concludes saying that it was reasonable by a citation to Abdallah with a pinpoint cite that explains why seizure in those circumstances was not reasonable. And I'm just having a little bit of trouble connecting the dots.
Sure. I would just go back again to my argument that pages 52 and 53 talk about the totality. The difference between Abdallah.
52 and 53 of what?
Abdallah, I apologize. I would say that Abdallah talks about the totality of the circumstances. The circumstances here are much different than Abdallah in the reasonableness.
But you're well familiar. I mean, we get these cases all the time where someone points to a case that goes the other way and distinguishes their case from that case and says, therefore, I win. But that's not the way it works. You have to show me something that comes out the way you want it to, and then show why this is like that.
I understand that, and if Your Honor would let me finish.
Please.
I do believe that is helpful because Abdallah was a larceny under 250 case. This is a murder case. The weapon has not been found. The
So can I just
object of
stop you there? I'm sorry to do this, but this is what I think, your opponent and I were going back and forth on. The murder weapon has not been found. That's an argument that, hey, it's relevant to the Fourth Amendment that there may have been evidentiary value to seizing the backpack. How was that argued below? Do we know how that was argued below? Because the judge does make the statement that your opponent says, suggesting, look, I don't have any reason to believe that they were going to find any evidence. Now, that may have just been with respect to the car, because we know the car is not the car that was at the site. But how was it argued below? Did somebody say, look, there was a legitimate concern? Or did the Commonwealth concede there wasn't a legitimate concern that there was any evidence in that backpack?
Your Honor, I think it's twofold. I think, and I do remember arguing this below, I do believe that we did not, we argued that it wasn't necessarily that we believed that particular weapon would be on him, but he was in fact a violent offender being arrested for a murder charge, that he was potentially armed and dangerous. And that is exhibited by the fact that Detective Marrero, before he was pulled over, broadcast to the entire fugitive unit the closest hospital, because they were afraid of this man and they knew what they were about to embark upon. So I would say that while it may not have been that gun, surprisingly it was that gun, but while it may not have been that gun, a backpack is known to be able to hold a weapon. He was
Let me
carrying
pause
that
for a
weapon.
moment, and I'm sorry, I know I keep interrupting you, but we got a lot to cover here. And just ask, as an intellectual exercise, had the police sought a warrant to go into the backpack, what would have been the basis used to suggest probable cause that there would be evidence in the backpack, evidence of the crime that had occurred several months earlier?
Sure. I think under the facts as they were presented here, I don't know that there would have been. And that's why we rested upon the warrant exceptions.
Wow. Let me suggest to you that had you come to this judge with an argument that said this guy murdered somebody and the murder weapon has never been found, it was a gun, that would be enough to have probable cause to search a backpack that was on his person, even if it was 4 months later.
Well, I appreciate that, and there, I would.
We may
so
not agree.
it depends on who you get. Yes, absolutely.
I'm not sure every judge would
absolutely, it depends on
That's
who you get.
absolutely
But-
really crazy if that's the truth, but okay.
But what I will say is I think.
Noted.
But what I will say is I think, given the situation at hand, they had probable cause to arrest him. Though he didn't raise the lawfulness of his arrest, the motion judge did find that there was plenty there. And again, knowing this individual, knowing he was violent, knowing that he could be armed and dangerous, knowing what they were going into. And I do want to turn to temporally again, Figueroa and the way of taking the backpack a few minutes excuse me, after the defendant had been arrested. I do think, Your Honor, Justice Englander was right on point. They can't do everything simultaneously and protect themselves, protect the victim, protect the defendant from claims, protect themselves from the defendant fleeing.
So I accept that as an argument. The difficulty with it that I keep getting stuck with is the following. When you say, hey, they could have searched that backpack immediately, at least in the circumstances of this case, we're just talking about trying to secure themselves, right? So to secure themselves, the best thing they can do is get him in handcuffs and out of the car.
And that's what they did.
Right, so they wouldn't search the backpack then. They would get him in handcuffs and get him out of the car. So the argument they can't do everything at once is sort of suggestive of the notion that they'd like to also simultaneously conduct an investigation as opposed to doing something that is security-based. Do you follow me?
I do, and I don't think that's the point that's not the point I'm trying to make with that argument. The point that I'm trying to make is what they were doing there was focused on the defendant, on the violent defendant who was much larger than them, that they needed to get arrested. And taking out the thought of pretext or the thought of investigatory search, which the motion judge expressly said that she did not find that this was pretext. Taking that out of it, the temporal proximity is important because this is all going on live, right? This is all going on all at the same time. There's multiple moving parts. They're trying to get the prisoner transport vehicle in. They're trying to make sure that the girlfriend who's now on scene isn't trying to get into the vehicle or trying to get at the defendant. They're trying to operate this scene while still making contact with Sergeant Detective Devane, who's back at headquarters, because there are multiple moving parts. They didn't know he was going to have a backpack on him when he walked out of the...
So this is a nice segue to my question.
Sure.
Because I think we need guidance on this. Well, I think I need guidance on this. I'm not going to purport to talk for Justice Englander or Chief Justice Green, certainly not Justice Englander, but it seems that we have case law that says, it's black letter law, search incident to arrest is contemporaneous with the arrest itself. Then we have these exceptions to that, which basically say some delay after the arrest, for the purposes you've just said, for example,
Correct.
is acceptable. But then we have cases like Pierre, which say an hour is way too long. And we have some other cases which say a minute later, maybe under certain circumstances, is fine. Based on these facts here, why is the, let's say, 6 minutes not too long under all of these circumstances?
Sure. I would first...
What is your, I need the best authority there is on this, whether, I don't care which way it goes.
Okay. I appreciate
As
that.
an officer of the court, I'm trusting you to give us the correct answer.
I appreciate that. I do believe that, I think, starting with the first half of that question, I think they didn't know he was going to have a backpack on him. They didn't know what they were going to encounter. They then find that he does, but as they find that he does, they're making their decisions on how to execute this arrest, right? How to pin him in, how to get him out, how to get him for their safety, public safety, all of that. So that's all happening live. You also have the fact
They have the car, they have the keys, they have the seizure of the bag.
It's all
6 minutes go
happening.
by. Best legal authority that this was either okay in this circumstance or it was not. I need the cases that are most on point.
Sure. I do think Figueroa is helpful. I do think if you look under New York versus Belton and I'm sorry, I'm going to say this wrong, Bongarzone, 390 Mass at 351. For instance, in that case, it says it's irrelevant that the occupant was standing outside of the vehicle. I think also if you look at Grasso and McAvoy, the section of suppression matters, section 12.3b2, there's a lot of information there that also goes towards the, you can't reorder the sequence, excuse me, you can't reorder the sequence because this is happening in real time. This is happening as they're finding things out. And the fact that they do have to call back to Devane because they didn't know if he wanted the car. This was a probable cause arrest. They were told to, this weekend, find this guy. Detective, one of the detectives finds that he's at his girlfriend's place in Brighton, calls the fugitive unit. They're there within a certain amount, a short amount of time. They set this up. They don't know that if they want that vehicle. They don't know if that's the vehicle that was involved. They don't know that he's going to come out with a backpack. So it's all things that they have to make decisions in real time. And they're the fugitive unit. They're not the homicide unit. So they're not there making these decisions because they know that they have someone that they have to check in with. So making calls back and forth within 2 to 3 minutes, within 4 minutes, within 6 minutes to determine, do we need the car? Can we relinquish this car? That's reasonable because they
That's the way
need.
they've chosen to operate. I mean, the chief's question, it seems to me, is pretty relevant, which is so the Fourth Amendment wants them to get a warrant. Could they have gotten a warrant?
For seizure of the backpack or for search of the backpack? Or both?
Well, that's a good question. Let's start with seizure.
I would say for seizure, they would have to freeze the scene and not relinquish the vehicle to the girlfriend at the time.
They've gotten a warrant to seize.
I'm sorry?
Cars parked lawfully, right?
I'm sorry, can you repeat that?
Could they have gotten a warrant to seize?
The backpack?
Backpack.
They could have tried. I don't know if it would have worked. It was on his person, so I think at that point, and according to the motion judge who also found that seizure was lawful, I think we could have made a case for sure. Whether it would have been accepted or not, as you, Chief Justice and Justice Englander disagreed earlier. But as far as opening the backpack, I think, and if I may just finish, I do think as far as opening the backpack, the motion judge did find that, Officer Murphy should have gotten a warrant, but didn't, and therefore it was unlawful. But because that backpack was seized lawfully and being transported back, it was going to be inventoried, and therefore it was inevitable discovery. And I think that is, that is here the crux of the matter, is that this gun was with the defendant when he was arrested and therefore was going to be discovered.
Chief, I have some more questions. So Figueroa says, as I read it, the question is whether it was within his lunge area or grasp at the time of arrest. And the way it's written, time doesn't matter. The way it's written,
Okay, yeah.
it could be the next day. We secure the car, we come back the next day, it's still search incident to arrest. Now, would that be inconsistent with federal law? What does the federal law say about time?
It does, I believe under Gantz, it does say that it has to be, kind of simultaneously, almost more contemporaneously. But I would argue that contemporaneously, we can play with that, and that's because of the totality of the circumstances. Contemporaneously to arrest, they're still effectuating getting him into the prisoner transport when all of the calls are happening. What does contemporaneously mean? I think that here, this Figueroa, Grasso's suppression matters, New York versus Belton, Bongarzoni, they all kind of play with that contemporaneously and say, here in the Commonwealth at least, and even under New York versus Belton, it says that you can examine the contents contemporaneous to incident to arrest. I would say that that is totality of the circumstances, and here it's not unreasonable, and that's the touchstone, is reasonableness, because here they're doing all these.
What's the federal law on the temporal limitation? Even assume that the law is as Figueroa says, that the question is what was within the scope at the time of arrest. What's the federal law on how long you can wait?
I don't know the exact timing off the top of my head. I do know that it's a contemporaneous. If there is a exact time, I'm happy to provide that in a 16L afterwards. I can look at Gantt. I can look at those cases, but off the top of my head, I'm not positive what the...
There's not an exact time, but to follow up on Justice Englander's question, have we ever held, or is there an example where we've held or the SJC has held in a situation like this where 6-8 minutes have passed and then the search occurs, we've held, well, that's close enough, that's contemporaneous?
Not off the top of my head. I don't know exact case, but I do think that Figueroa is, and even Bonger's own, which says it's okay when the defendant is standing outside of the vehicle. I mean, that has to be at least a minute or two, just physically to be able to.
Standing outside is one thing. In the transport vehicle, already away from the scene, is another.
That's true, but I would also point back to the temporal timing of they're making these calls to find out what's going on. And if the court has no further questions.
Seeing none?
Thank you.
The case, we have lots of questions, but we're going to have to puzzle those out on our own.
Extremely well argued on both sides. Thank you.
Both. We are in recess. We will return at 11:15.
Court or rise. Court, all rise, please. Court is open. Please be seated.
We continue our session with the fourth case on the list for hearing, the first of our civil matters, case number 2022 P1168, the Select Board of the Town of Pepperell and others versus the Pepperell Zoning Board of Appeal and others.
Good morning. May it please the Court. Christine Dieter for the appellant, Mass Composting Group, Inc., or MCGI. The Land Court erred in granting summary judgment to the Pepperell's Select Board and the private plaintiff abutters for 3 reasons.
Could you speak up, please, a little bit?
Certainly. For 3 reasons. First, and perhaps most importantly, the judge acted as a fact finder in this case. She ignored MCGI's evidence on the summary judgment record and failed to draw all inferences in favor of MCGI. Second, the Land Court should have adopted MCGI's narrow preemption argument that the town was preempted from second-guessing the Department of Environmental Protection's judgment on the composition of soils suitable for the reclamation of quarries. And finally, the Land Court erred in failing to address at all the question of whether the reclamation project constituted a use under the Pepperell zoning bylaw. Now, it's important to note, MCGI did not move for summary judgment in this case. So the relief that we're seeking is that the decision of the Land Court be reversed and remanded for a trial, because there are factual issues to determine here, and the judge should be able to make credibility determinations and weigh the evidence, but that can't happen on summary judgment. I'd like to address each of those 3 points, but first let me briefly go into some of the background here.
Before you get into that background, I am curious, because quite a lot of time has passed. And one of the factors that was apparent in the motion judge's memorandum of decision was the question of where DEP stood toward the eventual promulgation of detailed regulations. I should know this, but I don't. Has the DEP promulgated regulations, or are they still operating under the interim policy?
They're still operating under the interim policy.
Okay, and separate from that, it appeared to me from the discussion of the case and from the record that MCGI had not submitted an application to the DEP for approval of its proposal under the interim policy.
No, that's not correct, Your Honor. The proposal has been made, and at the time, and again, as you mentioned, this is going several years back, but there were discussions with DEP, and there was an effort as part of that process to get the meaningful input from the town on issues related to noise, placement, location, things like that that are contemplated under the policy. Those conversations broke down because of this litigation, and so we weren't able to get over that barrier with DEP.
So at the moment, we do not know whether, in the view of the DEP, the proposal, in fact, satisfies the criteria for the interim policy.
You're correct, Your Honor, that we don't know determinatively that it will, because we don't have that administrative consent order. But what we do have...
I mean, that's one of the interesting things to me in this case. Now, I recognize I had a few of these 240-14A cases when I was in a former life. But a lot of the precautionary language that we find in the 231A declaratory judgment cases around zoning is that we have this very elaborate administrative framework for review of actual projects, and a group of administrative officials who are charged with enforcement that quite often will frame and focus the questions of interpretation before it ever gets to review by a court. There's a question, in my view, of maybe not going to a jurisdictional question, but ripeness and exhaustion. 240-14A takes a lot of that out of the question, but where we don't know whether the proposal that was the subject of the motion judge's consideration of what constitutes refuse under the bylaw, whether that proposal in fact would constitute an actual use, setting aside your argument on use, that the DEP would sanction to go forward?
So let me respond in a couple ways, if I may, Your Honor. First of all, from an administrative zoning perspective, this matter originated when the town inspector issued a letter saying that the project was...
An advisory opinion.
An advisory opinion, and as...
And that was appealed to the ZBA, and that then precipitated a 17 appeal to the land court, and the judge said, wait, that's not an appealable event, the ZBA didn't have jurisdiction, this should go as a deck.
Correct. So certainly from a zoning perspective, we've exhausted all possible remedies there. But with respect to the...
Well, not really, because you have not sought a permit with an approved plan from the DEP.
And the reason that we can't get a approval from the DEP is because the town hasn't signed off on it. So there's supposed to be a discussion with DEP as to whether or not the town is on board and they feel that their concerns have been adequately addressed. And not surprisingly, given this litigation, the town won't say their concerns.
The town doesn't have veto power. They certainly have a statutory entitlement to participate in an open process, to have input, and to be heard. But their approval does not constitute an essential element in the critical path toward DEP final action on a proposal.
And while I agree with you wholeheartedly, Your Honor, the position that DEP has taken is that they will not issue an administrative consent order unless and until essentially this matter is resolved and the town's concerns are resolved.
So the actual, I'm sure that others understand this better than me, but the actual status is you have applied for that, I don't know exactly how you would call it, but something that would lead you to an administrative consent order from the DEP. That application is on file. That's what you're quoting when you say we proposed the following in terms of our fill, and you went somewhere down that road, the town balked, DEP has said we're not going any further. Is that the status?
That's correct, Your Honor.
Okay, so let me then go back to that, and you know, again, we are 240-14A is an unusual statute. It is one of the only, if not the only, instances where we authorize courts to issue an advisory opinion. But it is there, and it's there for a reason. The question I guess I have is, what is the question that we should be asking under 240-14A? It seems to me that the motion judge asked and answered the question whether the reclamation project described in MCGI's proposal would comply with or violate the zoning bylaw. And a different question might be whether a soil reclamation project approved by the DEP would violate the town's zoning bylaw. And that latter question, it seems to me, incorporates what you described in your introductory comments as your narrow preemption position. In other words, if DEP approves under its interim policy a particular composition of soils proposed for reclamation, then that is okay and it doesn't constitute refuse.
So, Your Honor, I'll respond in a couple ways. The first of which is that, you know, obviously for the reasons that I've described, we can't bring you that particular case, which would be a different case. But what we have here...
All of this is anticipatory, right?
But we can't move forward. We've come to something of an impasse here, so we don't have another avenue for relief. But what I think you have to do in this matter, what we need to do is look at it in the context of the summary judgment standard, which is viewing the facts in the light most favorable to MCGI. Now, we don't know ultimately...
What are the facts? I mean, let's say this went to trial. What are the facts that need to be tried?
My So the facts that need to be tried, and I'll start first with the question of whether this is a commercial dumping ground. And we use a lot of words here: commercial dumping ground, garbage, refuse, solid waste. But essentially, what we're talking about is whether or not this facility is a landfill. And so we had wanted to offer the testimony of Marilyn Wade. She's a licensed site professional. She's been an environmental consultant for 35 years. She served as a licensed site professional on one of the largest reclamation projects in the state, in Saugus, and she would have testified that when the bylaw is talking about refuse, as a practical matter, it's talking about the same type of material that DEP refers to as solid waste. And so under the policy...
But she can't, so there may be facts to be tried. But I think, isn't your opponent right that the court's not going to take testimony as to what the word refuse means in the bylaw, are they?
Well, so first of all, yes.
At the end of the day, it's a question of law.
The interpretation of the ordinance is a question of law, but how it applies to this particular project is a question of fact. It's a mixed question there. And, you know, this court did say in Mahoney...
The mixed question is whether what is actually going to be provided meets the definition of refuse. That's the mixed question.
Correct.
The factual question is what is actually going to be provided.
Correct.
But we don't know that yet.
Yeah, I mean,
Because
you're going to have a trial, and they're going to come out with an answer of maybe. I mean, I don't know how that's going to be resolved at trial.
Well, again, so we have the soil management plan in front of you. That is...
But we don't know that that's what's going to be used in the fill because we don't know whether DEP is going to require a more stringent set of criteria than what is proposed in the plan.
Well, we know it's probably not going to be more lenient, so if you can rule on this set of facts and know as a result that it would be covered, but...
Look, I understand that everybody would like to have an anticipatory guidance, but that's one of the reasons that you can sense my hesitation. It's not something that we ordinarily do.
But let me ask this question then. If what you're telling us is there's nothing, you have no place else to go without a decision from this court. Isn't that what you're telling us?
That's exactly what I'm telling you, Justice Englander. And that's exactly the situation in which declaratory judgments are appropriate. There is a clear controversy here. The town has made its position very clear. DEP has made its position equally clear. We're stuck between a rock and a hard place. So, you know, we have the proposal is before
But what you're saying then is you have to accept, see, there's something playing through the briefs, and I suspect it's what may be troubling and maybe the genesis of these questions. You say up to 5%, and then in your briefs you say, but of course it might not be 5%. And when you do that, you suggest that there might be a difference, and that difference might make a difference. And when you do that, it seems to me you have to be presenting it as you have to assume what we have presented is what's going to be. In other words, we have to assume 5%.
But let me clarify that, because that's...
You understand my point,
I do
right?
understand your point, but the criteria that DEP would set would be up to 5%. So then when the
I
license
thought what
site...
DEP said in their interim policy was de minimis.
De minimis. And then the specific
And
criteria...
then we don't know whether DEP agrees with you that 5% is de minimis.
That's correct, Your Honor. But what I'm saying is that in the context of the soil management proposal, even after DEP adopts it or modifies it, there will still be an up to percentage, and it is not certain, you know, even once the project starts.
Say that?
Because each load is going to be evaluated by the licensed site professional to ensure that it's compliant. And so as long as when that person...
Compliant with what? I thought I just heard you say there's always going to be an up to percentage. How do we know that?
That's because that's set forth in the soil management plan, and that becomes part of the administrative consent order. So,
assuming DEP thinks it's okay.
Right.
Correct, but there will be some soil management plan that is approved.
Unless and until DEP approves a soil management plan of some sort, and that soil management plan will incorporate upper limits of the composition of certain elements of the soil.
That's absolutely correct. And so there could be loads that go onto the site that include 0%. Those would be permissible. They could include 3%. That would all fall within the limits.
Here's part of the problem, and I think it is important, although we've got a lot of stuff to talk about. you are now acting as if these limitations are on a load-by-load basis. That's the way you're arguing it to us. In the briefs, it's not argued that way. It's argued as, well, that's going to be however many 100,000 trucks over the course of 3.2 billion, or I don't know what the number is, tons. In other words, how do we know it's even going to be on a load-by-load basis? We don't have any of that.
Well, and that's where the expert testimony was necessary, because Marilyn Wade, who does this, who's reviewed 1,000 analytical samples, would have explained that and could have provided the context.
That goes to the implementation mechanics, not to the interpretive question. And again, that goes into the regulatory oversight and approval process, not to a declaratory judgment.
But we're looking at the soil management as it's been proposed, and what there's no dispute about is that MCGI intends to conform with the reclamation policy. So you have to view the plan as if it's in conformance. And that's, again, this is exactly what Marilyn Wade...
Up to 5%, where does that come from?
That comes from the soil management plan. That is MCGI's proposal.
Okay, is there something from DEP that also has the up to 5% in it?
The reclamation policy itself states de minimis, but we have testimony in the record, again, that wasn't considered by the land court, from Phil Peterson, who was another LSP, that the criteria he chose were consistent with the criteria that DEP had approved for other projects. Again, that wasn't credited or given any consideration by the land court. And I see my time is up. I know there's...
I have a question for you. So this is with respect to the preemption argument. I'm at page 38 of your brief. You say the land court erred in failing to find the bylaw preempted with respect to the Mass DEP reclamation policy. Am I correct that the policy is not a regulation, it's not statutory, it's just that, it's a policy, right?
That's correct, Your Honor.
Can you give me the best parallel example you have of preemption applying with respect to a policy as opposed to a statutory requirement itself?
Sure. Well, I would refer you to the case we mentioned in our brief, Wendell v. Attorney General, 394 Mass 518. And again, what that talks about, I don't know that it speaks directly to the policy issue, but it talks to the issue of second-guessing the agency that's been specifically delegated to make the determination. And that's what we have here.
But typically, and I'm sorry to interrupt you, typically, as far as the case law I've looked at, that usually is being applied to a regulation itself, to something that is formalized by an agency, not a policy.
And I would refer back
That might be a distinction without a difference. I just don't think I've ever seen a case like this.
Well, I would refer you back to the Act itself, which specifically says that the Department of Environmental Protection shall establish, and it gives 4 choices. So again, it's delegated that authority, again, on the narrow question of soil composition, but delegated that to the Department of Environmental Protection.
But it shall establish regulations, correct?
Excuse me?
Shall establish regulations, correct?
That's the third section, the third sentence. That third sentence does not speak to suitability.
Okay.
The suitability is, DEP is given those 4 options.
Right, but again, I have not looked closely at the statute with this particular question of mine, but I don't think, when I read the statute, I understood it to imagine that we would be 8 coming up on 9 years out without regulations having been promulgated.
So respectfully, I don't read it that way, Your Honor. There's the first 2 sentences which talk about the composition of soil and ensuring safe and environmental protection.
Right.
And those give 4 choices to DEP. The third sentence is dealing with something else. It's dealing with classes of soil or types of projects. And so it presented the possibility for regulations.
I thought it said shall. I didn't think it said might.
No, the third sentence says the department may. It says that the Department of Environmental Protection shall establish regulations, guidelines, standards, or procedures. That's the first sentence. And then the third sentence says the department may adopt, amend, or repeal regulations establishing, and then it goes on to talk about specific categories of reclamation activities. And importantly, in that third sentence, it talks about local approval, but it talks about local approval related to size, scope, and location of the project. So again, not talking about suitability or composition there.
Well, you're talking about the Act.
I am talking about the Act.
So what about the interim policy? okay? In the end of the day, you're relying on the interim policy. The interim policy says nothing is going to interfere with the local government's ability to regulate the management. I'm looking for it because I should have it in front of me. I apologize.
Your
You
Honor,
make a
that's
distinction between management and composition, right?
correct.
But
And
it
that's on
talks
page-
about management of placement of. What's the difference between, I mean, I really struggled with trying to understand what this carve-out meant.
So I think MCGI's proposal is a good example of that, Your Honor. There were different portions of the site that were designated for different types of soil. So there are some soils that meet the criteria for residential use. There are some soils that meet the criteria for commercial use. And there are different portions of the site that would be used for each. So the town could create or regulate based on its bylaws issues related to those sorts of designations or determinations, or if there are setback requirements in the zoning bylaws that the projects needed to conform with, for example. Those are the types of elements, or noise ordinances as to when trucks could be coming on the roads. Those are the types of issues that the town still has authority to determine. But what they don't get to say is this load of material that DEP says is safe, it's appropriate for reuse, it's regulated, we're going to keep a close eye on it. They don't get to say that same pile of material is trash. That's a direct contradiction there. That's a sharp dispute. And if there are no other questions, we'd...
If what they say is not, this is trash, if what they say instead is, we don't think this should be placed here, does that fall within the carve-out of the interim policy, which has to do with the management of placement?
So the placement is within the quarry. So if we were looking outside of a quarry, perhaps, but because we're filling the quarry, that aspect, I mean, there is nowhere else you could place it and still conform with the policy, which is to refill the quarry.
All right, I'm sorry.
That's okay. We, again, we have, I don't know if you heard us in the previous case, but we certainly have lots and lots. Oh, you have another question? You have
Yeah, I
one
got
more?
another
Go for
The
it.
topic hasn't been touched on yet that I think is, you argue that this is not a use at all because it's prefatory, I guess, to use,
Correct.
right? But it's 7 to 9 years, according to your own proposal, where the property is going to have work being done on it, and you're going to receive $20 to $25 million for the work that's done on it. That's not a use?
No, Your Honor. And first, let me clarify.
Do you have any case that suggests that?
There's no case law exactly on this point, but let me say, in the first instance, this is another place where there are disputed facts, and so we're not asking this court to make a final determination on that issue here. We're asking for a remand. But there are absolutely actions that do not fall within zoning ordinance. For example, site preparation work is not covered by the zoning ordinance. Demolition is not covered by the zoning ordinance.
That characterization, it seems to me, incorporates as a foundational premise a rejection of the judge's conclusion that the fill material constitutes waste or refuse. And if you are successful on that foundational premise, we don't need to get to the question of whether it constitutes a use.
That is correct, Your Honor.
Okay.
I don't understand that.
I'll explain it to you.
I'm sure you will.
All right. If there are no further questions, we'll rest on our briefs. Thank you.
My understanding is that the parties are splitting their time. The town will have 10 minutes and the private parties will have 5. Is that correct?
Correct, Your Honor.
And you are?
David McKay from Myrick O'Connell on behalf of the Select Board for the Town of Pepperell. Good morning, Your Honors. May it please the Court. I'd like to address first an issue that the Court raised in its question to MCGI's counsel. The ACO process by Mass DEP is a discretionary process. In other words, it does not preclude a site operator from attempting to conduct soil reclamation activities outside of a permit that or an administrative consent order that might be issued by Mass DEP. So we do think that this issue is properly before the court because although MCGI has applied to Mass DEP for an administrative consent order, that process has not been followed through and come to a conclusion.
Well, in part because of this litigation, right?
That's correct, and I think that's the essential issue with respect to why DEP has not moved forward. It's not because the town has not participated.
If I understood what you were saying before you got to the suspension of the ACO process. Did I understand you correctly to say that MCGI could, if it chose, simply initiate a soil reclamation project at the quarry without going through the DEP?
Well, that goes to, there are two issues, I think, with respect to the use of the property. One is zoning, and the second is the ACO process. The ACO process is discretionary. MCGI would still be subject to all of the limitations of the zoning bylaw. My point with respect...
No, but my question is somewhat different. If there was no question that zoning authorized filling of this site with the soils described in the MCGI proposal, would they or would they not need to go to the DEP for approval before initiating that filling project?
They would not need to go to DEP for approval, and that's addressed in the first page of the interim policy, Your Honor.
Okay, that's I don't need that
Okay.
citation. I got it.
So first, we do think this issue is properly before the court because the ACO process is discretionary. Jumping to the balance of the preemption argument, and I do want to come back to the use questions that the court raised as well.
Well, can we start with commercial dumping ground?
Sure.
Doesn't there have to be a de minimis exception? It can't be that just because there's some solid waste in however many 100,000 tons of material are going to be put back into this area. There's some solid waste or there's some concrete that means you can preclude it, right?
No, Your Honor. And the reason that I would say that
so
is...
there is no de minimis exception?
I don't believe that there's a de minimis exception because...
Really?
Because even if this were just soil, it's still excess unwanted soil.
That's a different, okay. So
And the depositing certainly of excess unwanted soil at this volume at a site alone constitutes a...
Let's go to the economic argument that you seem to be making. You're suggesting that because MCGI needs to be paid to take it away, that therefore it is inherently waste.
Yes.
Do you have a case that has ever applied that standard? I know you have Webster's.
There are a handful of cases that talk about the financial benefit that the
Well, I understand that's been a topic
from,
of discussion. I'm just asking whether there is a case that uses that as the foundational definitional criteria for determining what is waste and what is not.
I'm not using it just as the foundational definitional criteria, Your Honor, but
Seemed that way in the motion judge's order.
Well, I don't think that was the only factor. The compensation part is certainly one of it.
You mean the composition part?
No compensation.
The composition part was part of it.
Financial incentive.
But I would also add that part of it was the fact that these were self-described by MCGI in its project proposal as excess soils. And MCGI testified that it wouldn't take them if it weren't being paid for it.
So if they dug them out of some other, if these soils weren't coming from somebody who was asking that they be transferred, but instead they had another property somewhere and they dug them out of the other property and brought them over, we wouldn't have the same issue? It would be fine then?
Well, no, it wouldn't necessarily be fine then, because I still think it constitutes a use that is not allowed under a permissive zoning bylaw. So
Getting to the definitional question of what constitutes a dumping ground, because what inherent in that is the conclusion that this material is refuse or waste. And what you're saying is because it was unwanted at one site, it therefore is excess, and therefore its placement somewhere else is the exercise of disposing of trash.
it's the exercise of disposing of unwanted material, which we believe is refuse under the definition of the bylaw.
Well, there are lots of things that are unwanted in one location that are beneficial in others. That doesn't make them trash.
That's true. In this case, though, what we're talking about is 3.2 million tons of soil.
It's already been removed. 3.2 million were removed. It's a quarry. Now they want to put it back, right?
Actually, no, Your Honor, and I'm glad that you mentioned that because.
Well, I'm sorry. The numbers may be different, but there was a whole lot that was removed.
There was some material that was removed.
They want to put material back where material had been removed from, and you're saying basically our commercial dumping ground bylaw prevents that under all circumstances?
No, Your Honor.
Okay, under what circumstances would it be okay?
If it's incidental or accessory to an allowed use. So reclamation by itself is not always prohibited. The problem here, and this is the major distinction between MCGI's case and the series of cases like Lowe's, Henry, Old Colony, Indian Head, and Richardson North, is that in all of those cases, the soil removal or the soil reclamation activities were at least attempted to be tied to an underlying allowed use. In this case,
Why should that matter? I mean, it's going to take them 7 to 9 years. How are they going to know whether the use that they're proposing is still going to be viable 7 to 9 years later?
Because
And what you're saying is if they don't give you a use, then they can't reclaim the quarry.
well,
Your bylaw precludes it.
they are seeking to do far more than to reclaim the quarry, Your Honor. They are seeking to construct a soil reclamation facility 299 feet high, about 100 feet above the roadway that's next to it.
Those aren't the fact that it's 209. That's not the reason that the town is taking the position that it's a commercial dumping ground. They're taking the position it's a commercial dumping ground because they're putting soil in there. Basically, that's what it comes down to. And I'm trying to is there any limit to that?
Wait, what could they ever fill it, what could they fill it with?
There is. If the soil, and the cases address this, if the soil is being brought to the site to actually reclaim it for a beneficial purpose that is incidental or accessory to an allowed use.
Why does it have to be incidental or accessory to an allowed use? Why can't it be we're trying to reclaim the site, and at some point, when we finally get 7 to 9 years later, this
Then
thing
we'll put an allowed use in.
Because that's not what MCGI has brought before the court.
That is
Because
exactly what they say in their brief. They say, we're going to take us 7 to 9 years, and then we're going to decide what development to put on top of it. That's exactly what they say.
actually, they don't actually put and suggest to the court that they're going to put a development on top of this, because that would require significant engineering that's not a part of the record. They're building a 100-foot plus high hill to completely cover the site, which is shown in their renderings that are part of the record before the court. And I think that is significant because.
We're doing this so that we can then put a development there.
But they have not attempted to show in any part in the underlying record that the work that they're doing, the soil reclamation, is incidental or accessory to any potential use that they would make of that site.
Well,
They haven't.
no use can be made of the site so long as it remains a hollowed out quarry.
That's actually not true, and that is contrary to the deposition testimony of 3 individuals from MCGI. And that is included in the record. It's volume.
Town's position is you can't fill it, you just have to use it as it stands.
That-
Is that the town's position?
That is not our position, Your Honor. Our position is that if the reclamation is necessary and incidental to an allowed use or to an accessory use at the site, then it can be permitted. But MCGI has skipped that process entirely, and that's what makes its case different from the other cases. In the other cases where folks tried to do soil removal or soil reclamation, they tied it to an allowed use. So for example, in the Richardson North case, that was a reclamation project that the proponent attempted to tie.
That, and I don't understand why it's important that it be tied to an allowed use. The question is this a commercial dumping ground? When I asked you, don't they have to be able to put in a de minimis amount of concrete? Instead of addressing that question, you immediately jump to, you can't put anything there because anything you fill is going to be refuse because it's unwanted where it's coming from. Right? That's the way this argument has gone. And I'm really trying to understand the town's position. Is the town's position that you can't fill this unless you know at the time exactly how you're going to use it when you're done?
The town's position is that soil reclamation standing alone is a use and that it's not a use that's allowed under the zoning bylaw, unless it's incidental or accessory to some other allowed use. And that's not inconsistent with other cases. If they could show, and if they attempted to show in any meaningful way that this use is accessory or incidental to an allowed use, then they could do it. But and they have not established a record during the discovery of the case, and the undisputed material facts do not show that the work that they're proposing, a $3.2 million or 2 million cubic yard soil reclamation facility is necessary in order to reuse the site. In fact, all of their witnesses testified that they didn't know that that would be necessary. They hadn't.
Where does the word necessary come from? I mean, I thought we were talking about whether it's a commercial dumping ground. Can we move to preemption for a moment? Because there was a disconnect in the briefs, and the reply brief did a very nice job of bringing us back to their argument about preemption is that what they're saying is preempted is a determination as to that the composition of what's being placed there is improper. And they say, but composition is in the DEP's world. What do you say to that?
I say, first, that it's only partially in the DEP's world, that the statute does not say that the DEP is the only agency that can address this or regulate this. Second, I would say that the zoning bylaw doesn't attempt to do that. The zoning bylaw does not attempt to classify, saying that some percentage of solid waste in the soil is okay, but a higher percentage is not. It doesn't attempt to regulate contamination or contaminant thresholds. It just simply doesn't attempt to draw those lines.
Your argument is, well, the argument that the court accepted was one based on the composition that was proposed, right? There's a second argument, which is the one you jumped to here today, that everything's refuse if it's unwanted. But the argument the court accepted was, hey, there's going to be at least 5% cement or, construction materials of some kind. Isn't that argument based on the composition of the soil? That argument that the court used to grant summary judgment in your favor?
Yes, but it was based on the zoning bylaw and the interpretation of the word refuse, which is not necessarily preempted by Mass DEP in this context.
Why not, where DEP is charged with determining and and has a process through an interim policy for determining whether the soil meets particular safety standards.
Because Mass DEP is not the only authority that can
How can
regulate
that be?
those things.
So if Mass DEP says it's okay, who could say, no, it's not okay?
I'm sorry, Your Honor?
I don't understand how they're not the only authority. Who's the other authority that could contravene the DEP?
Local boards of health can regulate that as well.
And the reason you make that argument is based on what language where?
So the language of the statute is actually quite narrow, and it refers to Mass DEP shall establish regulation standards, guidelines, or procedures for determining the suitability of soil. It does not go any farther to say that a municipality cannot also regulate those things. And there are a variety of different examples of two things. One of which is that when the state wants to preclude...
That's an argument that the local bylaw can go farther.
The local bylaw can go farther. There are certain examples of that, such as the Wetlands Protection Act.
You started to give us one. Why don't you finish that thought?
The other is that
No. Finish the thought of an example where the DEP regulates a particular topic, and absent a delegation by the DEP to local control, it remains open for local boards of health to impose more stringent regulations.
The Wetlands Protection Act, it's not a Board of Health, it's the Conservation Commission, but I think that is a good example of that kind of activity where local activity is not preempted. And I think what MCGI has...
That's by specific local non-zoning wetlands bylaws under the Home Rule statute, right?
Right. And I think that...
Doesn't the Wetlands Protection Act, though, contemplate that the local bylaws can go farther?
Yes, and I think there's nothing in this act that suggests that a municipality can't do the same thing.
No, but there's nothing that specifically authorizes it.
That's correct, but that's not I would submit that that's not the way the preemption analysis works. The preemption analysis doesn't preserve exclusive authority to the state or require some specific allowance to local authority. It has to be either expressed or implied in the totality of the act.
The difficulty is that if the DEP were to actually issue a permit, and then the local government said, no, we don't care that the DEP has said that this is safe, we're going to go further, that would be a direct conflict. That's a difficulty.
Well, so we don't have that case, but I don't think that's a direct conflict. I think that is an example where a municipality can regulate more stringently than the state might choose to do.
But the difference is that in the wetlands protection paradigm, the purpose of the Wetlands Protection Act is to ensure that the department is protecting wetlands. And if the town wants to impose more stringent protections, that's in furtherance of that purpose. In the case of soil reclamation, the purpose of the statute is to reclaim quarries. And if the town imposes more stringent regulations, that would operate in tension with that objective.
I think that was only part of Mass DEP's objective. The other part of the objective was to establish standards for the use of soils in those standards.
Ancillary to ensuring that, but they hold the field for that question.
But the act does not suggest that the state was occupying the field. In fact, the act suggests otherwise because
it authorizes DEP to commit certain matters to local control.
It does, Your Honor.
Which they have not done.
Correct, Your Honor.
Okay.
Which they have not done.
But if we were operating within an area that the DEP had committed to local control, we would be having a very different conversation.
We could potentially have been having a very different conversation.
I think we're going to have to leave it there. We're not going to resolve all of these questions. We're almost double the time that you had allotted, but thank you very much. It's been helpful.
Thank you, Your Honor.
For the private parties?
Thank you, Your Honors. May it please the Court, Jonathan Silverstein for the private plaintiffs. Your Honors, I'd like to pick up on what I think has been an important issue that needs to be addressed. Under zoning, any use of property has to be specifically allowed. there are two independent reasons why the land court's judgment should be upheld. One has been exhaustively covered today, and with the court's permission, I'm not going to retrod that ground, which is whether or not this is a commercial dumping ground. But I think it's important to remember, and this will get to Justice Englander's questions of my brother in a moment, that this use doesn't have to be found to be a commercial dumping ground in order for it to be not allowed. If it is a use, and I submit it is clearly a use, and I'll get to that in a moment, then it's prohibited unless it's specifically allowed. Now, we say, and we think the judge correctly found, that this is actually a use that's specifically governed by the bylaw and specifically prohibited by the bylaw. But this court doesn't have to agree with that in order to find it's not permitted under zoning.
Do you think that the bylaw, do you think, okay, let's suppose my use is as a single-family home.
Yes.
Can I build the single-family home?
If a single-family home is a use allowed
Or do I need
under
the bylaw to say an allowed use is the building of a single-family home?
The single-family home is the use.
And you don't need the bylaw to say, and you get to build it, right? You can't come, the town of Pepperell could not say, I'm precluding you from building that single-family home because there isn't an allowed use in the bylaws for building the single-family home.
Respectfully, Your Honor, I don't think that's an apt comparison.
Well,
there is.
Suppose that the reclamation project here was only going to take 6 months. They were going to take 6 months and they were going to put in 100,000 tons of soil. Wouldn't that just be essentially the same as building the single-family home?
No, it wouldn't, Your Honor, because they're not building anything. Let me take Your Honor's.
That's your brother's argument that you haven't yet told us what you're going to do when you're done reclaiming.
Your Honor, let me specifically address your point with a more apt comparison I would submit. Many zoning bylaws govern earth removal. Many zoning bylaws specifically govern the deposit of earth. And this is referenced in various case law. Now, if you are going to build a single-family home and you need to bring earth in for the purpose of building that single-family home, or you need to take earth out for the purpose of building that single-family home, then that may or may not be regulated under the zoning bylaw. There's
but you don't have to have a category under allowed uses.
Of course you do, because Your Honor
says an allowed use is taking soil out in order to build the single-family home, or putting soil in order to build the single-family home.
But you're building a single-family home, Your Honor, and the things that are necessarily incidental to doing that, of course, are allowed if you're allowed to build the single-family home. Here, they're building a mountain, towering 100 feet above the public way, 100 feet above the pre-quarry grade. They're building a giant mountain. Why are they building a giant mountain? Because they're getting paid $20 million to do so.
There's a place where it's 100 feet above the pre-quarry grade?
Yes, Your Honor. And that's clear in the record. It is, let's bear in mind what this.
Because the way I read it was not that, but that's interesting.
When you're using the term use,
yes,
and I'll let you get back to that in a second, but you're talking about the table of approved uses that's in the bylaw?
That's right, Your Honor. And anything that's not listed is prohibited.
So assume for the sake of argument that MCGI's project involves one of those many different approved uses. Then the filling of the quarry with soil would be incidental to that, and they could do exactly what they want to do as long as the end result is to have that approved use?
As long as the filling is necessarily incidental to that allowed use. And that's exactly what many cases have looked at specifically. Old Colony, Richardson North, and Henry. In all of those cases, the question was, are you bringing earth in? Are you taking earth out? And is that necessary for a use?
So as long as the end use is approved, is an approved use, and they need to build up, they need to fill in the quarry to get to that end use, they can do exactly what they want to do.
Right. But, Your Honor, you have to bear in mind, and so if the notion were, well, if we disembody this activity from any allowed use, and we don't even try to justify it through an allowed use, Richardson North, Henry, and Old Colony would all be meaningless decisions, because there at least those landowners tried to tie their activities to a specific use. And if we say, well, here's a property with a mountain on it, and I sell granite, but I'm just preparing it for some future use. I want to make it nice and level. I'm not justifying this based on any proposed use. I'm going to blast this mountain out, sell all the granite, make $20 million, not identify any use that this is necessary for, and that's not a use of land? Or I'm a lumber company. I'm going to go in, I'm going to clear cut this entire 30-acre property, sell all the lumber. I'm just clearing it for some future use. I'm preparing it. I don't have to identify what use that is. Whether or not...
When you put it that way, counsel, that's an interesting argument. I mean, the difficulty, and it's the elephant in the room, right? If this quarry sits there as a big hole in the ground, okay, and I think the chief sort of, expressed this before, that's not a very good use of the land. And this statute seems to be about assuming, in part, that people are going to fill back in these quarries so that they can be used, right? I mean, it can't, and the notion that the town can simply prevent that seems to be problematic.
But it's not, Your Honor. There are examples all over the Commonwealth where quarries have been reused for golf courses, for housing developments, for all sorts of things. None of them have come in and said, we're just going to fill them in and decide what to do later. They come in, they have a plan, they do what is necessary for a specific use, as opposed to not just replacing it, what was taken out, but creating a huge mountainside without even saying, well, here's what we need to do for a specific use. And again, in Richardson North, this court said, there at least, again, they were trying to justify that soil reclamation project of a quarry by saying we need to bring all this in to make an agricultural use of the land. And the court said, well, first of all, no, you don't. Second of all, this is a use and it's not allowed. And it was 2 million tons instead of 3.5 million tons. It was 3 million in revenue instead of 20 million, and this court said...
Panel of this court, that was an unpublished Rule 23 opinion.
It was, Your Honor, relying on Henry and...
Well, Henry and Old Colony were both excavation as opposed to filling, but I understand, I understand the point.
I think, Your Honor, respectfully, that's a distinction without a difference, because if this all comes down to, well, we're just preparing, then... It doesn't matter if you're bringing in or taking out.
Well, I understand cranberry growing is a little different from, okay.
And I would like quickly, Your Honor, because I know the court...
You're nearing double as well.
In the interim policy, the DEP specifically says that nothing in the interim policy eliminates, supersedes, or otherwise modifies any local requirements, and it specifically talks about applicable to, quote, placing the soil at the receiving location.
Skip the word management.
No, it says, that's separate, Your Honor.
Well, that's not the way I read it, and what you just quoted, you skipped the word management.
Well,
okay, we can read that, I think.
Yeah. Thank you.
Thank you, Your Honor.
Interesting case. And well argued on all sides. Thank you.
Great, thank you.
The next case on our list for hearing this afternoon is case number 2023 P180, Michael MEEHAN versus Laser Spot LLC and others.
Good afternoon, Your Honor. If it pleases the Court, I'm John McCarthy from Doherty, Wallace, Pillsbury, and Murphy in Springfield, and I represent the plaintiff appellant Michael MEEHAN. This matter arises out of an injury sustained by Mr. MEEHAN on May 28, 2019, when he was run down by a truck owned and operated by his employer. The issue that rests here, there's not a lot of disputed facts. The issue is the scope of two things: the scope of the so-called going and coming rule, which, as the Court knows, is a judicially created way of trying to explain what the statute means by acting in the course of employment. And secondly, whether the Court issued, and it's whether the Court erred, and it's our position that it did err, in finding the essential elements that the hundreds of cases and decisions in this Court and the reviewing board and the SJC have done to analyze this going and coming rule.
Excuse me, you started by saying the facts are basically undisputed. There seems to be a dispute over what was before the motion judge in terms of the Rule 9A supplemental statement of undisputed fact. I think we should be able to clear this up. So the question I have is,
Right.
My understanding is that you say that you did file responses to the defendant's supplemental statement of fact, and those responses were given in hard copy, and that the motion judge had that before him at the hearing, or before her, rather, at the hearing.
That's correct, Your Honor.
Okay. They say, as far as I can tell, that that was either not before the judge or not in the record. I just need to know where in the record we can find that that was before the judge.
I've pointed out in the reply brief a number of places where the judge referenced or talked about things that were in the actual hard copy that was filed,
Okay.
which was unfortunately not included when my staff filed the electronic copy.
I see. So there was a misfiling with the court, but prior to argument, you're saying you did file the responses and provided a copy to
Correct, Your
defense
Honor.
counsel.
And what appears in the appendix is what we submitted in hard copy to the court and to Attorney Agniti, who at the time was representing the employer.
Then that leads to my second preliminary question, which is in response to, this is at Record Appendix page 77, in response to a few of the statements, of supplemental statements of undisputed fact, your response is disputed, basically see the Moore affidavit. Is the Moore affidavit sufficient to defeat summary judgment on those issues? And the reason I ask is, typically we see evidence pointed out in an affidavit. The affidavit doesn't just say, this isn't what I meant, and the May 28th incident was not part of the lump sum settlement. We actually have documentation appended to it that shows that. The affidavit in and of itself is not evidence. What do you say to that?
Well, first of all, a lump sum settlement, as the court knows, is a very particular form of proceeding in the workers' comp venue. It uses up the past, present, and future indemnity benefits that an employee would get. And in this case, for Mr. MEEHAN's May 21st injuries. The Section 19 agreement...
Didn't the lump sum settlement agreement, by its terms, encompass both the 21st and the 28th incidents?
Well, that was the reason for I wasn't part of that, Your Honor, so that was the reason why Attorney Moore prepared the affidavit.
I understand, but the attorney's affidavit, going back to Justice Neyman's point, the attorney's affidavit doesn't determine the force of the official documentation or the order of the review board. It is the docket of that case that determines the legal consequence, not what the attorney has to say about it.
Well, let me put it this way, Your Honor. There was a lot of confusion about dates of injuries.
I understand, but the lump sum settlement is the final disposition, and with all due respect, after we issue our opinion in any of the previous 4 cases that you heard if you were sitting here today, it's not open to the attorneys in that case to go out and say to someone else, well, that's not what they really meant, this is what it means.
Except, Your Honor, there's 2 different things there. A lump sum settlement is different than a Section 19 settlement.
But, yeah, okay, accepted. I'm looking at the Section 19 agreement. That's what you want to talk about. And the Section 19 agreement explicitly includes, whereas the employee alleges he sustained an injury which is in dispute to be work-related to head, neck, back, and the lower extremities on 5/28/2019. So
Right.
how can we possibly read this agreement
Says it's in dispute.
resolved that workman's compensation claim as not including 5/28? How do we do that?
That's what the way it proceeded in the Department of Industrial Accidents, and has continued to proceed that way.
And it continued to proceed that way through to and concluding with the lump sum settlement.
No, that was the insurer had not paid Mr. Meehan benefits, medical or otherwise, for the May 21st injury or any other injury.
Right.
And that's what the Section 19 agreement was, to get him some money.
Right, but it also says the insurer agrees to pay any and all medically reasonable and necessary treatment pursuant to Sections 13 and 30 arising out of either of these dates of injury. That's paragraph 2.
But they haven't done that.
Well, but that's a fight over whether or not the insurer has complied with the agreement. That's not a grounds for a separate lawsuit.
Well, the lawsuit was filed separately in Hampden Superior Court. And the position that we took was that it was not a workers' compensation case for the May 28th injury.
Right, but
No, I understand that that's the position that you took, but that position
What's the evidence of that?
is foreclosed by its inclusion in the disposition of the claim by the Section 19 and lump sum settlement.
But the reference to it as a lump sum settlement is really misleading.
But you're supposed to have, I understand what your argument is. What we're just dealing with is, on this record, where is the evidence that it's wrong and misleading? There should be a ruling or order or some pleadings out of some court or agency that explains that, as opposed to just...
There was about a month ago a hearing in
That
front
wasn't
of
before the judge at summary judgment, though.
in front of Judge Daniels in the Department of Industrial Accidents. And one of the issues raised by the insurer in that case is the question of both dates of injuries. And the insurer has failed to pay benefits for the May 28th injury at all.
Well,
And-
when you say that, I don't understand that. I'm
Well-
looking at a document that says that it describes settlement amounts, it describes what's going to be done, and it includes May 28th on it. So how do we know? Is it your contention that you're allowed to, well, wait a second. There could be 2 things going on. Is it your contention that you could settle as you have with the Section 19 agreement and still bring the lawsuit that you've brought? Or is it your contention that what's written in this agreement wasn't followed? May 28th, 2019, there was never any payment for, and thus, as a result, we should be allowed to bring the claim in Superior Court. Which one is it?
That's correct, Your Honor.
The second one.
They did not pay on the May 28th case, and that,
But doesn't this say that they're going to?
well, as you saw from Attorney Moore's affidavit, she indicated that that was withdrawn in front of the judge.
So where
Where's
was
the record of that
withdrawal?
in the case?
Well, there wouldn't be, there's two things there. One, it was at conference that it was clarified and the judge issued an order of payment for the May 21st injury.
Where is that order in the record?
I don't believe so, Your Honor.
So how do we know that? So this is exactly where Judge Neyman started with his first question out of the box. We have a document that is in the record that suggests to us that the May 28th has been resolved through a workman's compensation claim. You say it hasn't been. Look at the affidavit of Ms. Moore. We look at that, and it doesn't include anything that allows us to see that the May 28th was never paid.
Well, what I would say under the summary judgment standard, in terms of reviewing the evidence that was in front of the court and the Superior Court, in the light most favorable to Mr. Meehan, there was no countervailing affidavit. There was nothing from Laser Spot at any point in time that contradicts what Attorney Moore said.
Why don't we move to the other point then? What about Mendes? I mean, Mendes seems to be pretty darn close to this case.
Well, and Mendes comes down on the issue of premises. There are three things that the courts have all looked at, and the reviewing board has looked at in the DIA. They look at, obviously, whether the employee was engaged in work activity, in which case it's undisputed here he was not.
But he wasn't in Mendes either. They were sitting on his doorstep waiting to go in.
I know, I'm going to get there.
So let's take that one out of there. That one's not required, right?
That's point three. But the second point is whether he's on a mission, and he's not on a mission for the employer.
Again,
And the
not
third
Mendes
is
either.
he on the employer's premises, and that's Mendes. That's all of those cases. They analyze whether or not the injury to the employee occurred on the employer's premises.
Why should we care?
So, I'm sorry.
No, go ahead.
So, unless your client, what are the premises? Just the trailer in which?
No. The employer's premises? Yes, just the trailer. The rest of it is a huge swath of paved land with a warehouse and distribution center for Home Depot.
Is that the job site?
Well, the job site?
Yeah.
Yes.
The work that they are doing.
Laser Spot has a contract to bring trucks onto this property.
Right.
And move trailers around for loading and unloading. And that's it.
Right.
They have
but
no
so
lease.
So that what they are doing there is under some arrangement, which isn't in our record, but some arrangement, a sub-license, subcontract, some arrangement with Home Depot. And everything that they are doing in the course of their employment for their employer on a site that is, albeit owned by Home Depot, but is the site where Laser Spot is tasked to do its work through its employees.
Yeah, it's public area. There are tractor-trailer trucks.
It's private area, but it's area where Laser Spot is authorized to operate.
By contract.
By contract, and ancillary to that contract, Laser Spot's employees are directed to park in a designated employee parking area.
No, in a parking area designated by Home Depot.
Right. For whom and at whose direction Laser Spot and its employees are operating at that location.
But there's, what do you mean, in the parking area?
They have to walk from the parking
It's incident to the entire activities of Laser Spot at that Home Depot location.
No, it's not.
Or are they supposed to get there?
The trailers are brought in by other vendors or truckers.
I understand, but how are the employees supposed to get there? Are they going to
Employers,
stow away on the
employees,
trucks, or are they going to be dropped in by helicopter?
well, they park where Home Depot told them to park.
That's exactly right.
So as part of their job is they got to park over here and they got to walk from here to there. Doesn't that seem like incident, in the course of their employment?
In the same way as in
No,
medics.
it's not. The standard is there's no coverage for coming and going to work.
This is not coming and
So-
going. This is in the course of.
Well, let me ask you it this way. Are you suggesting then that the only way that your client could receive workers' comp benefits would be if he was injured inside or literally adjacent to the trailer where he clocks in and out? Otherwise, he has to bring a superior court or district court case?
Under the court decisions, yes, Your Honor.
So
So he would literally have to be
If
in,
he's on someone else's premises,
so he would have to be eligible for workers' comp, either in the trailer in which he clocks in and out, or let's say basically within arm's reach of it. Otherwise, no workers' comp benefits.
it's not.
I just want to make sure that I
Yes,
understand
that's what the case is.
why would he get him for being in the trailer? The trailer's on Home Depot's property.
Because the trailer belongs to Laser Spot.
Oh, okay. All right.
That makes
It's where they have the punch clock.
Thank you. Okay.
Thank you, Your Honor.
You're from Laser Spot?
May it please the court, Patricia Gary for the appellee.
Please speak
Need
up.
you to speak up, thanks.
Yes. So, Your Honors, I'd like to give you the citation to a case that I think has every issue that we've been discussing as to the premises, and it's not in my brief, so I'd like to point it out to the court. It's DeFranzo's case, and the citation is 459 Mass 338, and it's a 2011 case.
338, at what pages?
344 is really the whole explanation. And so it starts out by saying there is this going and coming rule, which my brother is resting his position on. But there is also an exception to that for premises. And we agree, and it's undisputed, there are no disputed facts in the record, that this was not Laser Spot's premises, it was Home Depot's premises. But there is also a line of cases, and this is lower down in this page, where it says that the premises exception has been extended to injuries while an employee was arriving to or departing from work on a private passage to which the employer had the right of use, and this is permission to use, such as a stairwell, elevator, parking lot, or outdoor passage. And then the leading cases for that, which are cited in my brief, are Mannering's case, which is 290 Mass 517. It's a 1935 case. It's really the leading case on a private passage in which the employer had permission to use.
Is this a private passage?
Yes.
Suppose that the parking lot had been, a half a mile away.
So there are cases that address that, but there is another parking lot case, which is MEEHAN's case, another case that I don't have cited in my brief. But we got his reply brief, and so I couldn't file a SIR reply. This issue of control came up in his reply brief. And so the issue is really not control, but it's permission. The leading case from the appeals court is Lee versus Pelletier, which is 20 Mass App Court 915. And that case does talk about control over an access road. So if there had been like a long access road to get to, say, a highway, that's that case. And it was just the language that the court used, saying the employer had control over that access way, and I'm sure it did. But there are other Supreme Court cases which say all you need is permission, and that's what we have here, is permission
Why don't
to
you
use.
tell us about one of those?
Okay, for example, Mannering's case, it's a 1935 case, but Mary Mannering was a cleaner, and she was in a building on Beacon Street in Boston, and there was a passageway, a private passageway, to the main street from the building. She fell on snow or ice on that private passageway, and the court said it was agreed by the parties that the employer did not own the underlying fee of the passageway, but had a right of way on it, and the employee had the benefit of those rights. So that case is direct.
And the employee was held, therefore, to be acting in the course of employment at
Correct.
the time she fell.
Yes.
Because, so if she'd got to the public way no longer, then she's going or coming, but in this private passageway on the way to the public way, she's still acting within the course of her employment.
Yes, that's correct. And again, DeFranzo's case really sets out, all these cases have just one point in them. And the good thing about DeFranzo's case is it kind of sets it out saying,
You didn't cite DeFranzo's case in your brief.
I didn't. But that's because we didn't realize at that time that the argument was being made was control.
Thought
And
that was in his opening brief.
I'm not sure that it was. I think it was just the going and coming rule that was in the opening brief.
I believe it was in the brief, and the judge made a finding of control.
Okay.
And the judge addressed it and distinguished coming and going from course of employment.
Okay. Well, regardless, we have Mannering's case cited. We also have Lee versus Pelletier, and then Zapponi versus Central Construction Company, which is 334 Mass 146, 1956. That's an important case because it's on public land. None of the land is private. And you have these cases, and in fact, DeFranzo's case was similar to that case in that we're talking about public land, and there are workers on a street in Boston.
So
That was, yeah, but that's the one where the street had been blocked off for them to
Yes.
work. Yeah.
Yes, exactly.
I'd like to go back to the Rule 9A dispute. You go to great lengths in your brief to dispute that there were responses to the supplemental, to your supplemental statement of undisputed fact.
I don't think we need that for this to prevail here or to get an affirm in this case, but
Well,
just
I mean, it seems to me
pointed
you
it
went to
out.
great lengths to dispute that.
I did
The parties
because-
should know, either you had it or you did not, and either
We don't have it.
you never received it.
I don't have it. But I also
You
have
say
to
So
say,
you are making a representation that neither you, no one, you never saw
Can't-
their statement,
I can't
their
say
response.
that no one did.
Which is date stamped in the copy that they put in their appendix, I believe, which
No,
appears to.
what they put in their appendix is not date stamped. What we put in our appendix is date stamped. So
You're making the
so-
representation, just to be clear, that you, A, never received.
I don't have a copy of it, nor does our firm.
How about the affidavit?
We don't have a copy of that. But also,
In
Your
that
Honor,
it wasn't, are you making the representation it wasn't before the judge at argument?
I don't know that because the way that I looked at the transcript and there is discussion about this lawyer, but her name appears on all the other documents. So I think her name was Catherine or
I don't
Kath.
understand that, though. I mean, the judge's,
It's possible.
opinion sure seems to indicate.
I agree with you
she
that there's
had
a
it at
possibility
argument.
that
Well,
she had it.
You should either know or not know.
I don't know.
But I think this is the reason for the questions.
Okay.
When we receive an argument that says this was not part of the record,
It's not
and then we
part-
pick, let me finish.
Sure.
And then we pick up the judge's opinion, which indicates to us that it was in front of the judge at the time that she addressed it, and indeed she relied on it. That's a problem. Something is wrong. Somebody has told us something that doesn't make any sense, and they should know the answer to the
I
question.
don't know the answer to it. I went on to the docket to get the documents that I put into the supplemental appendix.
Did you talk to your prior counsel if you were
She's
not
no
present?
longer at our firm.
Did you talk to your prior counsel before you made an argument to this
I
court
did.
that this was not part of, let me finish.
I've talked to her about the case, and, my understanding is that all of the documents that we had are in our firm's computer system and on the court's docket. There's references to being, the judge got it before the hearing. That's possible, if he handed it to her at the
I
hearing.
think before you argue that this was not part of the record, which is an important argument to make, you need to know the answer to that
Okay,
question.
I don't-
And I think you had within your power the ability to find out the answer.
I did by going onto the court's
Well,
docket. and
or
that's
if you
what I
don't
did.
know, don't say something that you don't know.
Well, as far as the affidavit, I guess, as far as the Rule 9A responses, that's what's on the court's docket. That's what we have also. That's all we have. So we got those. In other words, that's what we received. So, I mean, I never received, or our firm never received, to my knowledge, the other responses. That's all we ever received. Whether they ever got to the court, I can't say. We didn't receive them, and they weren't e-filed with the summary judgment materials. So I just thought I would point that out because I couldn't find them, anywhere, and I thought, well, why don't I have them, and why aren't they on the court's docket? But beyond that, I don't think it's really necessary because I don't think any of the facts are really in dispute. That would go to the argument that you're talking about, the Section 19 argument. And I will point out that I agree with my brother that this wasn't a lump sum agreement, a Section 44. And I think that the judge may have gotten that wrong, the lower court judge. But I don't think that matters because it was a Section 19 agreement. And all of the facts are stated there that it was for both accidents, or both incidents. None of that, I don't believe that that's necessary for your opinion in this case or to affirm. I think that, and I don't want that to create an issue of fact, that we don't think that we need to have that to prevail. But it is in the record. It's there. I know that my brother's trying to create a dispute of fact any way that he can, and so that could be a way that he's trying to do that. But I don't think that, I think it's a matter of law here. I don't think it matters at all.
You think what is a matter of law?
That this going and coming rule doesn't apply in this case. And again, I would say that at Mannering's case, Zapponi versus Central Construction, Lee versus Pelletier, Mahan's case, and I don't know if that one's in my brief either, so I want to give you the citation to that, 350 Mass 777, 1966. That's a parking lot, just like this case, in which Mary Mahan was going to her newsstand at a bus, MTA bus parking area, and she was struck by a bus in that area, contiguous to the area of her newsstand, and the SJC agreed with the reviewing board that she was permitted to walk there. So that, again, is public air and a public parking lot owned by the MTA, but she had permission to walk there to get to her newsstand. And all of these cases, the issue is permission. It isn't control. And that we don't want there to be a dispute of fact over whether Laser Spot actually had control over this area, which my brother tries to raise in his reply brief. In our view, the issue is not whether we have control. That's not what the law says. The law says whether there was permission by the employer. And there is also some good language within the Zapponi versus Central Construction case, which says that the reserved parts of Biltmore and Lamartine Streets constituted the place of employment and as such are like the employer's premises within the significance of the rule that accidents occurring on the employer's premises while going to or from work are found to have occurred within the scope of employment. And I think that is really how we would like the court to affirm the judge's ruling, and just the fact that control is not needed. And I believe that the lower court judge did, and it was Judge Goodwin, did use the word control, and I don't think that that's necessary here. I don't think that That's really what the law says. There is one case, which Lee versus Pelletier, it's an appeals court case, which talks about control, but the real issue is whether the employer has permission to use the area and whether the employee is using it with permission.
You cited DeFranzo's case to us. I've had a chance to look at it. And it says, we have also extended compensability to injuries arising while an employee was arriving to or departing from work on a private passage to which the employer had a right of use. Would you consider the parking lot that the plaintiff was walking on a private passage or a public passage?
I consider it to be a private passage, but I don't think that, again,
I think it doesn't matter either way.
I think as long as there was permission, and in this case, it's well documented in the deposition transcript.
What's interesting, though, is that, and again, I'm reading DeFranzo for the first time, so I'm not trying to sneak this up on you, but the next sentence of DeFranzo I just saw says, such cases have been distinguished from those in which the relevant injury occurred during a commute on a public way.
Correct.
I understand this isn't a commute, but so the public-private distinction may have some teeth to it. I just don't know. I haven't read that case yet.
I think the commute, when we're talking about the commute, we're talking about the commute on, a public highway or a train or something like that, which DeFranzo also distinguishes
We're not
and says.
talking about being on essentially the premises of where the work is being done.
Yes, it was Home Depot's premises. I don't think there's any dispute that it was Home Depot's premises. It's just that Laser Spot had permission to use that area.
Understood. Thank you.
Thank you, Your Honor.
Thank you. That brings us to the sixth and final case on our list for hearing this morning, today, I should say. Case number 2023 P670. This is a case involving the termination of parental rights. I'll remind counsel that the case is impounded. Please avoid any reference to the names of any of the individuals involved, mother, father, child, etc. And again, my understanding is that you'll be dividing your time on the appellee side of the V here with 10 minutes for the department and 5 minutes for the child. That's right. Okay.
I believe it's good afternoon, Your Honors. May it please the court, excuse me, I am Attorney Diana Spanos here today on behalf of the appellant mother. And I'm sorry, I've got a little scratchy voice, so I'm doing my best.
It's the season.
Yeah, it seems to be going around.
Thank you, it is. Excuse me, the department removed the child in this case from the mother when he was approximately 3.5 years old. At that time, the department had been involved with the mother for about 1.5 years prior to the removal. And I make that point because the department was actively working the case with the mom. They were checking in on her, checking in with the providers at the time. At that point, they saw the child to be happy, young, developmentally on point, pretty much. Maybe a little bit shy, but bonded with his mother as well as his maternal grandmother and cousin who lived in the house. The department only removed the child when there were allegations made of medical neglect by the child's pediatrician. The concern was that mother was primarily not following up with providers. So the removal was done, and then about 6 days later, they finally got in touch with the specialist who had a different point of view and said that he didn't have those similar concerns, that mother hadn't.
That specialist you referred to had only met the child twice, am I right? Did I read the record correctly as to that?
I don't know if it was 2 times, but he had not seen him as frequently, and he commented the pediatrician did have more contact with the child. But within weeks after the removal, the department, the foster mother at the time told the court investigator that she had the department's approval and they discontinued services with that same pediatrician, and for whatever reason, they felt there was a conflict or, that the doctor had a problem with working with this child. So at that point, they were only using the specialist and a new pediatrician. They also discontinued the services with the allergist, who was really one of the providers that the original pediatrician was pushing hard for mom to get involved with, even though they had done allergy testing with the child, and the child had no allergies.
So I lose the thread of why, you mentioned all this in your brief, and I lost the thread of why it was important. What is the significance that we should take from the fact that there was a changeover in the providers after the child was removed?
Well, there wasn't a changeover. Well, there was a changeover in the pediatrician, and the foster mother made it very clear she was only using the pediatrician for medical, colds, speaking of myself, and routine matters, and that they were relying solely on the specialist and his advice as to the child's asthmatic concerns, and his advice that he didn't need to see the allergist. And
But what's the significance of that in terms of, is it undermining findings? Your brief focuses on what happened up until the time the child was removed. The judge doesn't focus on that.
No.
The judge talks about other things. When the child is removed, it turns out that his dental situation is so radical that he has to have 4 root canals at age 3.
Yeah.
Okay? And then a deterioration in visitation, which occurs after the child is removed, a deterioration in, what appears to be a deterioration in mother's substance abuse after the child is removed, including an admission by the mother that she falsified records with respect to that. So I'm trying to, you're over here, and why is that important? Why is that important?
Well, I mean, I will acknowledge on the record that probably mother should have pursued custody at a temporary custody hearing, and she didn't. There was a stipulation at that point, because I think those reasons are important. But regarding the substance abuse, up until the child was removed, there was no indication that if mother was abusing substances prior to, while she was his custodian, there's no evidence to show that whatever she did harmed him. And if in fact she relapsed, and she did because she entered a program at one point, her problem, mother was on a Suboxone management program. There's no evidence to suggest that she relapsed with, opioids. But she did occasionally take a Xanax because she felt it helped with some anxiety. I'm not suggesting that that's, something that the model parent does, but she did that, and she went into a program, afterwards to get help. The smoking was a major issue. That, prior to the child's removal, interestingly enough, no one smelled cigarette smoke on this child at any time. The department was in the home. They never smelled cigarette smoke. The maternal grandmother was against that. Yet the judge relies heavily and finds mother not credible when she says she's not smoking. The dental needs, I wish, the record really doesn't say a lot in there. The judge makes a finding that mother missed numerous dental appointments, and yet there's no evidence that there were dentist appointments set up.
Isn't the most significant part of the dental that they trace it back to something that the child had been in like 9 months before, and the dentist had said, you've got to do A, B, and C because this child has serious issues. The dentist followed up on multiple occasions. I think the judge makes findings on this. The dentist followed up on multiple occasions. Nothing was done, and ultimately it resulted in 4 root canals.
I disagree respectfully with...
What part did I miss?
I don't believe that there is evidence in the record. Mother says she took the child to the dentist twice, and because of his asthma, and they knew he was going to have some kind of, surgery that would require anesthesia, that she needed to have a specialist opinion as to if that was safe. And so she had to go into Boston for that, and they were waiting for that appointment. The dentist followed up like 9 days after the removal. That's the only time I am aware in this record, in good faith. That's the only time I'm aware.
Of course it is, and I accept that. I read that, what I just said to you is
Yes.
my memory, however poor it may be, of what your opponents put in their brief.
Well, I know, and it is, I stand by what I wrote in my brief, that I don't believe that there is evidence in this record to suggest that mother missed an appointment on, March 5th and whatever. It's specific dates. There's none of that. Mother, in fact, after the removal, met with the court investigator, and she broke down in tears and said, she was devastated. She had no idea how bad it was. To the department's credit, they allowed her to go to the hospital where she was able to speak with the doctors that did the procedure and was there to comfort the child. But she legitimately did not realize the extent of it. And more importantly, she said that no one ever told her that by using albuterol, that you should be rinsing the mouth out. And there's no evidence in this record. And again, the child was 3.5. It's not really clear. I think he was diagnosed with asthma around age 2.5 maybe. There's something in there in December 7, 2017. Mother had brought the child in to the doctor, and excuse me, the doctor had said she was mixing up the two medications, the albuterol and so the judge makes a finding that mother was giving the medication wrong. Well, that was probably the first time he had had an asthma attack in 2017. He would have been around a little over 2. There's no evidence in the record that she ever did that again. In fact, mother testified at trial that they had given her some kind of a color-coded plan, as to which medication to use. So, moreover, what I found really troubling with this case is that the child, as much as he was described as kind of an average toddler in the very beginning, the pre-adoptive mother testified that at age 6, she had just put him on antipsychotic medication. I mean, his behavior really deteriorated. And the focus seemed to be that this was related to mom and mom's visits. The other thing that was happening, we all know COVID-19 came and the child's visitations became virtual, which had to have been incredibly challenging, for any parent during that period of time. So she was trying to have these, virtual visits, and at one point they reduced them to 30 minutes because an hour was too long, for any child to sit. But the pre-adoptive family that stepped forward is a paternal relative, and they told the department right up front, we're not interested in an open adoption. They had their own reasons. And I would suggest that those reasons aren't necessarily attached to what's best for the child. It might be best for them, but not best for the child. So the visits up until that child was placed in the home had gone really fairly well. Even the virtual visits had gone reasonably well. The social worker noted that mom really did her best to try to engage over a screen and, really tried. And more importantly, she said that the foster mother testified that the foster mother kind of acted like she was her friend. So the foster mother's with the child in front of the screen and, it seemed normal. But when they moved the child into this pre-adoptive home, everything changed. And it wasn't, I would assert, it's not just that it was the contact with mother, because when they tried to do a closing visit with the prior foster home where the child had been for 18 months, the child wouldn't get out of the car, threw himself on the ground. I mean, this is unrelated to mom. something else was going on. Excuse me. The department, says that I'm relying, or mother's relying too much on that one line, that mother is very bonded with this child, and that was however many months before trial. Well, once that child was in that home, the visits really didn't, happen. The pre-adoptive mother said she tried, I encouraged him, this is your special time. Well, when the pre-adoptive mother would be back in the doorway whispering because she didn't want to come into the room, presumably, I think it's because she didn't want to be seen on the screen. It just set it up badly. So I just would suggest that I think the evidence was insufficient, even though this court may agree that there were some concerning things in the record. There's a lot of things that the record just didn't really answer. And mother would argue that the trial judge really relied on things that you cannot find the nexus to create the necessary linkage to terminate her rights. So if there's no further questions, I would rely on my brief.
Thank you.
Thank you. And a glass of water, please.
Yes. Please help yourself. Be careful. Sometimes those pictures are a little bit unpredictable.
May it please the court, my name is Alex Rothschild of Latham & Watkins. I represent the Department of Children and Families. It's the department's position that this judgment should be affirmed in all respects. There's clear and convincing evidence that mother is unfit to parent the child, and termination is in the best interest of the child. At bottom, this is a case about a parent who demonstrated an unwillingness or an inability, for whatever reason, to look out and provide for the medical needs of the child up until the age of about 3.5. Child was removed in February of 2019. Mother did not contest the removal. Mother then proceeded to fail to make progress in improving her parenting skills over the course of the next 3 years up until trial in May 2022. In fact, as of February 2021, so over a year before trial, mother stipulated to her unfitness and agreed to having child placed in the department's permanent custody. And over that next year leading up into trial.
So the trial's March of 22?
May.
May of 22.
May of 22.
February of 21, she stipulates to, essentially stipulates away her ability to retake custody, right? She stipulates to permanent custody with the department.
So she does stipulate, yeah, she stipulates to permanent custody with the department.
What context did that stipulation, was it made like in a what is it, I can't remember the name of the process, but every so often the department comes back and takes another look, right?
It's not clear from the record exactly what preceded it. The child moved into the pre-adoptive parents' home in August of 2020. It's not entirely clear that that's related, but kind of in terms of the timeline, removal is February 2019. Mother fails to make progress in her action plans. The goal is changed to...
That's at the end of 19?
Yes, that's correct. Other key events is mother attends rehab in June of 2020. And at the same time, there's just a lack of progress.
Well, is it accurate that the visitations were going forward even... I was just reading the findings on this, but there were visitations that started, in March of 2020. They started virtually. Child is 3 years old. Mom is going to those, right? She's showing up regularly? No?
That is not correct, Your Honor. And a number of mothers' arguments really require either disregarding factual findings or taking inferences in mother's favor where the trial court didn't do it. But there is a clear record, it doesn't require any inference to see, that her visitations became inconsistent as early as fall of 2019.
How often was she having visitation with the child?
It really varied, and it became increasingly.
In 2020, when we went over to the virtual visitation, how often was she visiting with the child?
I would need to check, but I can tell you that there were a lot of missed appointments along the way, a lot of canceled appointments and no-shows, and it started before COVID, and it certainly started before August of 2020. It's just the history of visitation is pretty well set out in the judge's findings of facts.
Well, I'm reading it now, and before June, when she goes into rehab.
Yes.
Between March and June, there's only an indication she missed one visit. And that's why I asked the question, how many did she make? But apparently that's not in the record.
So I'm not sure about that, Your Honor.
Wait, I interrupted you. She goes into rehab. How long is she in rehab in 2020?
She's in rehab for a number of weeks, and then she kind of goes through to like a post-rehab safety house kind of facility, and that is the facility. Like, safety house might not be the correct word, but it's kind of
Tell us why she went into rehab. What the substance abuse was?
Well, so the mother failed a drug test for Xanax. And at trial, mother claimed that she just went to rehab because she wanted to learn more about herself and more about sobriety, which kind of goes to a broader point, which is there's a consistent lack of accountability, not just with the substance abuse, but with her candor about her participation in mental health treatment and other kind of steps forward in compliance with the action plan. And that continued even to trial. In trial, mother continued to maintain that she had been sober since 2020, even though she was confronted with her fall 2021 failed drug test for Xanax again. It's just, there's a lack of growth and a lack of improvement, and that is what is so problematic in terms of we are evaluating her parental fitness in May of 2022, and then asking yourself, is this parental fitness going to improve? Do we have any evidence that's going to improve? And the evidence is clear and convincing that mother is unfit, unfortunately, and termination of her rights is in the child's best interest.
What do you say to your opponent's statement that there is evidence of the mom ignoring dental advice or knowing the dental problem prior to the time of removal in 2019? I'm looking at the bottom of page 15 of your brief.
Yes.
In fact, there is evidence of only one pre-removal dental appointment in the record. It occurred in July 2018. Then over to the top, when the court-appointed investigator spoke with that dentist, the dentist remembered the family well, and you quote, and you have a cite there. Did the judge make those findings?
So the judge did not specifically put this block quote in there, and the issue of whether or not this appointment happened in July 2018 is not specifically in the findings of fact. However, there is a finding in the findings of fact about the mother misrepresenting to the department that she had taken the child to a dental appointment in November 2018. So that is in the finding of fact.
Where are the findings on the dentist stuff?
1 second, Your Honor. I'm just looking brief. Oh, finding of fact 45 is what the
45?
yes. Excuse me, that would be page 45, I believe.
Oh, page 45.
No, I'm sorry, Your Honor.
All right, I'll locate it. I was struck by those findings because they had to do with mothers. I was struck by the evidence in your brief because they had to do with neglect
Yes.
that occurred prior to removal. But I think what I'm learning is that what you put in your brief is not actually in the judge's findings.
So with respect, Your Honor, so the fact that mother reported taking the child to a dentist in November of 2018, which turned out to be false, is not that is actually in finding, that's finding of fact number 45. So that information is in there, as is.
And there is the report of the investigator, Dr. Smith.
I see it.
Yes, thank you. And I'm sorry, and so.
And that's at record appendix page, well, it's lengthy, but at the exhibit record appendix, page 24, under the summary and conclusion, is that mother has expressed to this investigator she was unaware of child's significant dental issues, placed the blame on the lack of information on the pediatrician. However, when the investigator, spoke with the local dentist, she noted that she had conducted a dental examination on child which indicated need for extensive dental work, had established an additional appointment time with mother. Those appointments, as well as other appointments, were no-shows.
Yes.
So there is record evidence of it.
Right.
I'm not sure what the judge found, but there is record evidence.
And I apologize, Justice Neyman, I didn't mean to interrupt you. And so, first off, there is record evidence about this July 2018 appointment. There's record evidence about mother's misrepresentation about a November 2018 appointment. And what is absolutely just beyond dispute is the actual state of child's mouth at the time of removal. And so mother says that she didn't know about, that child's albuterol could cause this sort of dental decay, and she had no idea the child's condition was that bad. The child's 3 years old, so at best that means that mother just never looked in the child's mouth and never participated with the child's dental care. It's just, it's a compelling detail. And so.
It would seem to me to be likely extraordinarily painful to have 4 teeth that are so bad that they need root canals.
I could not imagine. And so, ultimately, child was removed because of mother's inability to care for the child's needs. Since the time of removal, child's needs have only grown. So that's one part of the equation here. The other part is that mother has not shown progress in her parental capacity. And so after a while, enough is enough. It's appropriate, and it's in the child's best interest to terminate mother's parental rights and let child start a new life with the pre-adoptive family.
All right, thank you. We'll hear from counsel for the child.
Good afternoon. May it please the court, Morgan Russell on behalf of the child. So I come here today requesting that this court affirm the decree terminating mother's rights because it is in the child's best interest, and it is required for this child to remain safe. Now, my sister has focused a lot of her argument on what happened prior to the removal. However, the child's circumstances at the time of trial and mother's circumstances at the time of trial rendered her unfit and unable to take care of this child, regardless of the reasons. She had several shortcomings, but in totality, she was not unable, and she had no insight or increased insight into what this child needed, but what could keep this child safe, essentially. Now, this child, we just talked at length about his dental work. As of the time of trial, 3 years later, he was still requiring dental services to manage his teeth. His asthma had not improved. It was well maintained because of his pre-adoptive home, because they had strict adherence to what he needed to do for his albuterol treatments and his, COPD medications. He had also been showing signs of psychiatric needs. He was hearing voices, he's on antipsychotic medications, he's on SSRIs. These are significant needs that, the record is very unclear whether the mother could meet those needs for the child at that time. She was only dealing with asthma and obviously not really addressing his dental needs prior to removal. If she couldn't handle his asthma when he was a 3-year-old, I don't know how mother is going to be handling his psychiatric needs, his continued asthmatic needs, his IEP educational needs. All of these things only increased, and she still lacked insight into what this child needed at the time of trial. And to answer Justice Englander's question about the review and the adjudication initially in review and redetermination. So mom did stipulate to her unfitness. This was in February of 2021. Essentially what that is an agreement that mother is then unfit, but that termination may not be in the child's best needs. So
That was review and redetermination. That's what that was. So that was a review and redetermination proceeding that led to that stipulation.
no, so that stipulation was the initial finding of mother's unfitness in the permanent custody of the child to the department. Thereafter, every 6 months, any party may petition the court for a review and redetermination hearing to see if things have
Right,
changed.
what I was asking is, I think it's February 2021, she stipulates to the department having permanent custody, so she's not, there's like another step. The first step is custody is taken, that's in 2019, she stipulated to that. Now we're in 2021, mother stipulates to permanent custody with the department. I was trying to get at what proceeding led to that? What was the process? What was the context in which she stipulated to that?
That's agreement by the parties, Judge. That takes it off the trial track. If mother acknowledges...
What off the trial track? The care and protection?
The care and
proceeding?
protection matter, yeah.
All right.
So that basically it brings it to a conclusion so that the parties aren't going in and out of the court every 3 months.
Got it, okay.
And then just to quickly address the visitation issue that was also argued by my sister. Visitation very clearly is not in the child's best interest. It's a discretionary order that the judge can make if there appears to be a positive bond between the child and their biological parent, and if it's in the child's best interest. I would argue that the record is clear that at the time of trial, there was next to no bond between, or even positive relationship between the mother and the child. And we could argue at length as to why that is, but it was what it was. Now, COVID happened, visits were virtual, and she was having them for every single week up until about December 2020, that it became bi-weekly, and then be it virtual. But she was, and this is a child with significant behavioral problems. He has a hard time sitting still. He has a hard time with the video. He has a hard time with even the department workers that he meets with every month coming into the home. So it's not surprising that not seeing mother, not having that relationship with her, caused him some struggles and dysregulation. He was physically refusing to have visits with her. So I find it hard, I would find the judge hard-pressed to find in his discretionary authority to find that it would be in this child's best interest to continue to try to force this relationship with the mother where there was none.
More to the point, it would not be an abuse of discretion for the judge not to reach that conclusion.
Absolutely, absolutely. If there are no further questions, the rest of my brief.
Seeing none, thank you. That will conclude the session. Thank you all.